Okay. Buongiorno a tutti. Hi, good morning. We might get started. Welcome again for those that were able to join us for dinner last night. That was very lovely, but great to see you all here bright and early again. My name is Brody Warren. I'm from the Hague Conference on Private International Law, the HCCH. But I'm here with two distinguished experts today, so I won't long. But first of all, Professor Caterina Fratea from the University of Verona, Associate Professor of European Union Law. Sorry, okay. Associate Professor of European Union Law, and she's been with the university for some 15 years, I've just heard. And yes, and does a lot of different things, but principally her areas of focus are European Union law, including European Union immigration law and competition law. And importantly for this panel and also for this conference, she contributed to the commentary on the regulation as well. So that's a very important part of her work that's relevant for us today. So I think I will pass over to Katarina to give her introduction, and then we'll hear from our distinguished speaker after that as well. Thank you.
Yeah. Okay, sorry. Thank you very much, Brody. Yes, very briefly also on my behalf, thank you for the invitation. Thank you for the organization and for Etsuanuska for the wonderful welcoming and the wonderful dinner of yesterday night. And yes, thank you also for mentioning commentary, and not because I've written it, because it's just a very small, tiny part, but mainly because it is a very important part of the project that we are quite proud of. I think that we will soon be published online if Alexander confirms that. And we hope also to have a paper copy quite soon. So also we invite you to make reference to the website in order to have access to the commentary and have all the necessary information about it. All the staff members contributed, so it was quite hard work, and I think it will be a good job when it's going to be finalized. And of course, thank you to Alexander for all the dedication and passion he put in this project, all the work that he has been carrying out in this past long 2 years, I would say. So thank you for that. Yes, mainly before not really introducing, because Alexander is the real expert here in this panel, so the distinguished speaker. But yes, on my behalf, since also the electronic documents will be deepened by you today, and also during the parallel sessions will be some contributions as well. Very briefly, of course, we know that this regulation was presented as a very important tool, because we have, the Commissioner for Justice said, we have something like 70 million European citizens living in another country than their own. So this tool, even though we can now say was not as used as we hoped it would be used, and maybe there is also space for the recommendations in this regard, but of course present itself as a very important tool for the daily life of European citizens, especially considering the three main areas, right, in which it operates. So eliminating all the red tape for citizens, and of course not necessary authentication stamps, and no need for official sworn translation thanks to the multilingual standard. And also, let's say, third area, no need to, or need to accept also the certified copies if the member state accept the certified copy for the same documents. So all these three actions that the regulation puts in place are, of course, extremely important for the simplification of the circulation of public documents within the European judicial area. some hurdles are now existing for electronic or digital documents, as we want to call them. You said yesterday, you already mentioned yesterday that these hurdles, these obstacles are not themselves related to the regulations, but are the normal obstacles that we encounter when we deal with electronic documents. Of course, there are in the regulation specific provisions, Recital 9, Article 12, regarding this kind of documents, but thanking you again. I leave the floor to you in order to explain better to us about these issues. Thank you very much.
Thank you. Thank you very much for introducing this session.
Introdotto questa sezione.
It's already. Well, it's an article by article commentary, so you'll find clearly an overview of all articles plus some significant recitals. Rather than showing you everything. Sullo schermo vabbè, quello per vedere.
Sorry, may I just take the opportunity, as I was just reminded, for the people here to fill in the questionnaire and to give it at the desk downstairs. And for the people connected, you will receive a link on the chat of this streaming. We kindly invite you to fill in the questionnaire online as well. Thank you very much.
Questo website. So just to give you an idea of the commentary, you can see on the website of the project all the authors that contributed to the commentary. So you'll see members of the project partners as well as some external members. As you may realize, the regulation covers different areas. So for instance, it wasn't easy to have someone commenting on the part that concerns criminal records. It's not something usually I think many of us work every day with. So also the European dimension of criminal records and cooperation in criminal justice, it's something that to some of us it's pretty new. So we looked for someone that had some knowledge in this field. So if you go on the website, you see all the authors that we wish to thank for their contributions. So rather than giving you an overview of the whole commentary as we did yesterday with the comparative survey, the idea was to focus on one aspect that we've developed in the commentary, and I chose again some uneasy terrain, some uncharted waters, and these are the electronic public documents. So do not expect any solution, any clear-cut answers to all the issues that they know very well in The Hague, that I think every registrar in Italy or elsewhere in the European Union knows. But we really wanted to, with this project, to shed some new light on issues that otherwise sometimes are unexplored. And unfortunately, we as lawyers usually pass as very conservative, and everything we have to turn on a computer and sign digitally. It's something that not necessarily is welcomed everywhere. So, but clearly this is the future, and I think it's pretty much fascinating. So, we try to dig a bit deeper into the electronic dimension of the regulation. Now, since we are hosted in this wonderful premise of ANOSCA, I also wish to mention the sort of grandparent of, let's put it this way, well, in general of the DXB project and of electronic documents, because when we in Verona started to think of partners and approached then Innsbruck, now the partner of the University of Graz, we also thought immediately of ANOSCA, because ANOSCA ran, now it's about 10 years ago, like this, a pilot project, which is called ECRN, European Civil Registry Network. And it was an effort, as you can see, among 14 EU public authorities to establish an electronic platform for the exchange of civil status documents. It was a pilot project funded by the EU. There is a video showing how it worked. So it was the very first effort by one of our, well, by two partners, EVS, the European Network of National Register Association, was also very much involved in this project. So this is sort of the grandparent of our today's project, and in this project, ECRN is also mentioned in the documents that eventually led to today's regulation. Okay, electronic public documents. What is it that we're talking about? Electronic public documents, we sometimes think of PDFs, but an electronic public document is not necessarily a PDF as we are usually used to deal with. It could be just, pure strings of codes like an XML, so pure data without any layouts. One aspect that's related to regulations, not mentioned in the regulation, are the use of XML schemas developed by the Commission to allow interchange and code the content of the multilingual standard forms, which is something that's probably it's in there. It's been used, but we haven't found experts covering this area by national authorities when they incorporate the multilingual standard forms into their systems. Also, they are clearly free to use whatever kind of coding and programming to integrate the multilingual standard forms into their databases. Talking about electronic public documents also leads to the standards, not EIDAS standards, but different standards that comply with the EIDAS standards. And for instance, I don't know how many of you know about EXADIS signature, which is a bit unknown, but exists. It's official qualified signature, besides some other standards like the PADIS and CADIS signatures. Also, one aspect that covers electronic public documents is the very little used and implemented direct transmission of electronic documents among member states. IMI, it's not meant to exchange documents within the framework of the regulation, but there are other instruments that do foresee a direct exchange of documents among public authorities, but that wasn't the purpose at this stage of the regulation. Electronic public documents are meant to be further developed under Article 26. The 26 is a very common review clause of the regulation, and that envisaged a report by the Commission on the first period of implementation of the regulation in 2021. We haven't seen even a draft yet on that, but I can see how difficult it is for the Commission to provide such a report, given the efforts we had to put into our project to collect information really on what's going on with the regulation in the member states. And we saw that yesterday. But there will be another report, the most important report, the one that should lead then to suggestions for review of the regulation in 2024. And here, in both reports, the article mandates the Commission to cover the use of electronic systems for the direct transmission of public documents. So it's going to be clearly more and more important in the future of this regulation. Let's try to find some answers. The regulation is, I believe, that's my personal opinion, we couldn't really share all the opinions of our project among the partners, but it's my opinion that the regulation is far too silent when it comes to electronic documents, whose circulation but not use falls within the field of application of the regulation. Also under Article 23, best practices, and those best practices are the practices should be exchanged in the ad hoc committee under the regulation, should concern also electronic public documents, but there is still a gray area in this field. And we see this in the national reports, we see this also in the discussions carried out within the ad hoc committee of the Commission. Now, what does the regulation say about the electronic dimension of public documents? Recital 9 says that each member state should decide in accordance with its national law whether and under which conditions public documents in multilingual standard forms in electronic format may be presented. Whether and under which conditions. So it's not that there's just how, it's even whether they should be and could be presented. Now, you understand that this recital clearly says this is another world. You should just apply the regulation when it comes to paper and wet ink. If it comes to something which is electronic in the air, well, then everyone's still up to do whatever they want. But this is a recital. You know, mostly lawyers here, or all lawyers, so we know that recitals aren't really binding, also, although they provide an important guideline for the interpretation of any legal instrument. So we'll see now what another recital says, but this recital then is exact, as very common with recitals, the wording, then you find in the bending article 18, second paragraph of the regulation. It says, and that's everything we would basically find in the regulation, in the provisionary part of the regulation. This regulation is without prejudice to the application of union law on electronic signatures and electronic identification. Without prejudice, that's everything. What's in there, that's what we needed to discover during our research. So what kind of electronic documents? There are different ways of classifying electronic documents based on the survey we carried out. We have digitized certified copy of a paper document. So since still the vast majority of public documents are on paper, hard copies, what you very often get, it's basically a scan of a paper document, and we'll see. Now this digitized copy is certified, so there is some sort of electronic signature seal attached to it. And if we get something attached to just the PDF file, the image file of the document, of the paper document, we need to subdivide that kind of document according to the standard that's used to digitally sign that image file. We might have an original electronic document, so that's really the one produced from scratch or, through digital resources, which is the native, if we want, electronic document. Then we have electronic document that bears a code. That could be a barcode, a QR code, another kind of code like a string, alphanumeric string. And we also have digitized copies of paper document without any electronic signature or seal at all. What does the EIDAS regulation say? What's in it? Is an electronic document that's under the definition provided by the EIDAS regulation under Article 3. Any content stored in electronic form, in particular text or sound, visual or audiovisual recording. To some extent, this is the definition you find also when it comes to evidence in the single digital gateway regulation. What does the EIDAS regulation then say in general on electronic documents? They say an electronic document shall not be denied legal effect and admissibility as evidence in legal proceedings solely on the grounds that it is an electronic form. So how would this apply to public documents? You just say this is not a public document because it's an electronic document. If we were just to, move from this definition and somehow put it into the public documents regulation. So even an electronic document that has a barcode, it's an electronic document, and not just because a signature is missing, which is the highest standards under the EIDAS regulation, it shouldn't be considered an electronic public document. What type of signatures? We have three kind of signatures that are contemplated by the EIDAS regulation: the electronic signature or seal, the advanced electronic signature seal, the qualified electronic signature or seal. And the one that's more significant is a qualified electronic signature, because it should have, under the EIDAS regulation, the equivalent legal effect of a handwritten signature, which also applies to the seals in the same terms. And then we have this very special qualified electronic signature based on a qualified signature issued in one member state. So this is the strong signature when you use a qualified electronic signature. But what does it then mean when this qualified electronic signatures or the signatures complying with different EIDAS standards are applied to public documents? If we look to Interrecitals 21, the last periods, they say, they read as follow. Neither should this regulation cover aspects related to the conclusion and validity of contracts or other legal obligations where there are requirements as regards form laid down by national union law. So although this period in the recital refers to private law instruments, how we would call it, so contracts and a sort of obligation among private parties, usually private parties, it means that clearly the EIDAS is just setting standards. It does not oblige member states to review the form their law provides for certain legal agreements. Okay, so forms are still decided at national level, and we know, every country has its own regulation rules on the formalities that some acts, some legal acts, agreements, and contracts, and deeds, and so on require. But the very last period in this recital, it's crucial because it says, in addition, it should not affect national form requirements pertaining to public registers, in particular, but that was just an example given, in particular commercial and land registers. But the recital applies to any public registers, and population registers are clearly public registers. So although it's again a recital, but then we would have to talk more about the EIDAS regulation. It's pretty clear that the purpose of the EIDAS regulation is not to oblige member states, to accept a public document in an electronic format from another member states, because if they have requirements as to the form for including a document in public registers, well, the EIDAS regulation has no legal effect on those provisions at the national level. So what actually happens is that we do see that most member states, when they have electronic public documents, they do use the qualified EIDAS electronic signature and seals, well, usually signatures, but in some cases, especially when you get something out of a database, it's an qualified electronic seal. But there is a lot more than just EIDAS signatures around. And as we mentioned, we found QR codes, barcodes, serial numbers, alphanumeric strings, quite a variety of, let's put it, ways of accompanying an electronic public document. What is interesting is a pending case that it's actually the very first case ever on the EIDAS regulation. It's been triggered by a Bulgarian court. The case before the Bulgarian court is an administrative document. It's a tax fine for VAT. And how was this administrative document of the Bulgarian tax authority signed? It was signed with something that in Bulgarian was labeled professional electronic signature, a professional electronic signature. So, lawyers are very good in finding all the ways to find a ground for annulling any kind of bad legal document against the interests of the clients. I said, what is this? This is not in line with the EIDAS. It's not even defined by Bulgarian law what a professional electronic signature is. So what should we do with, the injunction by the tax authority? Is it valid? Is it null and void, whatever? And so they raised a few questions, and which to some extent I'd say might be of interest also if we look into the validity of electronic public documents within the freedom of the regulation and say, is it impermissible for an administrative act issued in the form of an electronic document to be declared invalid if it has been signed with an electronic signature which is not a qualified electronic signature. And then the other questions are, in the entry of a qualified electronic, is the entry of a qualified electronic signature in the certificate issued by the trust service provider sufficient for a finding to be made whether or not an electronic signature is a qualified signature, or must the court establish compliance with the EIDAS standards? So it's like asking, okay, if the provider, the one that is used to sign the document, tells me, certifies, has an entry, says, okay, this signature is a a qualified signature. Should just I rely what's been said by the provider, or should I verify that content? And so by the same token, it's if I receive a document, that the issuing country says it's a qualified electronic signature, should I just be happy that the issuing country said it's a qualified, or should I verify that the signature on the public document is really a qualified signature, for instance? Third question, in a case such as that referred to above, in which the provider qualifies the electronic signatures as professional, is that circumstance sufficient to establish that there is no qualified electronic signature because of the difference in the name, in the absence of a qualified certificate from the provider, or is it necessary to establish whether the signatures fulfill the requirements for a qualified electronic signature? So again, what should I do? How far should I go? And then another thing that I was saying, okay, the first three questions are the most interesting ones, but also the fourth might be of interest somehow to our regulation, because another issue that was raised and was brought to the attention of the Court of Justice is the fact that the person that used the digital certificate to sign had its name, his or her name in the certificate in Latin and not in Cyrillic script. So, it's like, the whole issue that somehow was also discussed, debated within the ad hoc committee of the commission was how shall we deal with different alphabets than the Latin majoritarian, so to say, alphabets. And so it's like, how shall we deal if we get a public document it's without the original Greek or Bulgarian name in the Cyrillic or Greek alphabet, and I just get a public document with that name? Should I recognize that document to really be referred to that identity without having? Because the question is, given that the person identifies with the Bulgarian script of her name, of their name, okay? So we'll see. There is nothing on the website apart from a few documents and the questions. So we don't know the position of the Advocate General. We don't know when the court even will decide the case. But I think it's worth keeping an eye and watch the place. So let's look into issuing electronic documents and what to do. So it's undisputed that member states are free to regulate whether and how to issue electronic public documents. We've seen the recital that's about being presented. So here we're talking about issuing electronic public documents, and it's undisputed. I mean, we've seen the EIDAS regulations that you decide whatever kind of formalities you want to apply to contracts and so on. And this clearly applies also to electronic documents. So there is no obligation anywhere within the regulation to issue digital documents. Absolutely no regulation. Even if we were to look into the single digital gateway regulation, I don't know how familiar you are with that, so maybe I just spend a few more words on this regulation. It's not enforced yet. I mean, it's not something that you can still benefit of as of today. The idea is that behind this regulation is the idea that a citizen, any person actually in the European Union, should have access to some basic essential services, or just a lot of services from everywhere in the European Union without the need to move to another country, approach personally the authority and get the paper that's needed, the documents needed. And clearly in a European Union, when you want to really have citizens and people and companies exercise the fundamental economic freedom of establishment, providing services, etc. You could want to cut the red tape. And so why obliging people, find someone in another member state because that public authority says, no, you have to come before my country, place by hand, sign your request, get the application, pay the money on cash here, just before my eyes and everything. So what they did with the first effort is to provide a digital gateway. Okay, it's like a digital counter everyone can go to, and so members, they will be obliged, so that's not on a voluntary basis, will be obliged to provide certain services entirely online. Well, not entirely, and that's the point. You are entitled to get almost to the very end as a citizen online, but the output of your request could be by old-fashioned snail mail. The output of the procedure is delivered electronically. That would be very much welcomed, or when necessary to comply with applicable law, union or national law. So if I decide that national law says this kind of birth certificate is only issued on paper, it's in the national law, and that's fine with the single digital gateway regulation. So it will be delivered by physical means. I don't know whether on the back of a donkey or carried by a pigeon flying from one member state to the others, but you don't get it by email. You don't get it electronic. So we are still far from having a birth certificate, a certificate of residence, habitual residence delivered by email from any member state. So there is still some reality from the past that obtains still today and will get paper documents. But at least we can ask and pay for them online. Receiving electronic documents, that was about issuing. That's very little to say. Member states are free. But the problem is that those member states that have decided to embrace the third millennium, what happens? I think that the member states should not consider regulation recital number 9, what we read at the very beginning, as giving them carte blanche. It's not like that because member states seem to be pretty much free when it comes to electronic documents, they can do whatever they want. So they can refuse utterly to receive any electronic documents. Recitals are not binding, and e-documents are the future. And you certainly do not want citizens to get caught in a sort of cul-de-sac where, my member state, that member state delivers only electronic documents, but have to use them in another member state where they say, we don't like electronic documents, we don't accept them. So you're like caught in between, someone said, that's the only thing we deliver. And they said, that's the only thing we receive and want to, be handed with. And you don't want citizens, to end up in this horrible scenario. So what might be the right way of applying the regulation to public documents? I think it's the principle of non-discrimination. Sorry, there's a typo. A non-discrimination in state practice. Non-discrimination, I'll show you what it means. Well, it's a general principle, of European Union law, a non-discriminatory approach between nationals and non-nationals. So they should all treat e-citizens in the same way. And this non-discriminatory principle is in line with the EIDAS regulation and the standards that the EIDAS regulation sets, and also what we find in a single digital gateway regulation. Sorry, I have, excuse me. Well, I had a few notes that I wanted to show you. Well, let's see if I put them elsewhere. No, I want. Oh, goodness. Oh, sorry. Non-discriminatory means that, for instance, if we look at the EIDAS regulation, it says that you should treat signatures equally. For instance, if a certificate is issued in one member state, you cannot refuse the validity of that trust service provider of that signature just because it's not issued by a trust service in your member state, because if it complies with the EIDAS standards and in the subsequent secondary instruments that were developed to provide details. Oh, well, excellent. That's why we have a wonderful chair. It provides solution for every issue. So for instance, the a single digital gateway regulation at Article 13, paragraph 2, letters C and D say cross-border users are able to identify and authenticate themselves, sign or seal documents electronically as provided for in regulation 910/20 to 14. In all cases where this is also possible for non-cross-border users. And letter D says cross-border users are able to provide evidence of compliance with applicable requirements and to receive the outcome of the procedures in electronic format in all cases where this is also possible for non-cross-border users. So if I'm entitled to get something entirely online because I'm the citizen of that member state and I'm approaching that member state, I should be in exactly the same position if I identify myself according to the standards for electronic identification under the IDAS. You can't tell me, no, I deliver it to you because you're Italian and you're identifying as Italian on my governmental website, but because you're German and Austrian, certainly you identify according to the IDAS regulation, but no, I don't deliver it to you. So you can't really discriminate when it comes to this. And also Article 13, third paragraph of the Single Digital Gateway Regulation, it's pretty much similar. So, and we see also the principle of non-discrimination in the ICE regulation. So what is the idea beyond that? Is that if you get a document that if your state practice uses electronic documents, you can't really say, well, I like my national EIDAS compliant electronic documents, but I don't like other EIDAS compliant and public documents because they come from another member state. That's definitely not acceptable. So if your state practice says, again, remember that recital of the EIDAS regulation that says public registers, okay? And then basically you can do whatever you want. If your national law says, that public registers are filled, entered with just paper copies. Well, if you accept electronic documents for your public registers, you can't say, well, I just like my national electronic public and not the others. So that recital definitely cannot be invoked because that would be discriminatory. Why could you enter, say, an electronic birth certificate into the national registers? And you can't say no, but the other electronic digital electronic birth certificate from another member state, I don't accept it because actually I like then just paper documents. No, your state practice must be applied without any discrimination based, as long as documents are EIDAS compliant. So let's see what then is problematic. Well, everything that remains problematic, what does not comply with the EIDAS signatures and standards. That's problematic because then it's really up to the member states to decide what they will do. And here, member states are free, and we already know it from the regulation. They are free to define what a public document is. It's not up to the receiving country to define whether what's been presented to the destination authorities, whether this is a public document or not. That's entirely regulated, but entirely within the framework of the regulation, but essentially it's entirely regulated by national law. So I could say potentially that if a scan of a paper document is done within the context of a public authority, then it becomes a public document, even though it's just a scan, it's just an image file. So we found situations in the national reports where electronic documents not complying with qualified e-signatures and seals under the IDAS standards are still considered public documents and electronic public documents. This might be files without any signature or code. Unusual, but we have cases where you say, well, you take the digital document, you print it out, and the printout is a public document, exactly as the digital document. Files with only graphic codes for verification, very common. I guess it's also pretty much known to the Hague Conference when it comes to apostille. And as I said, we found barcodes, QR codes, alphanumeric strings, serial numbers. And it's up to the receiving member state to accept these electronic public documents, so outside of the framework of the EEIDAS regulation. And it's probably it is. It probably is up to each member state to accept them. The commission, the ad hoc committee of the commission should work on electronic public documents. But last week I was invited to deliver the final results of the Identities on the Move project, and I saw quite a scene in the commission because the commission was pushing to publish on the what's in the minutes. So well, it will be in the minutes of the meeting. They're really pushing to provide information on electronic public documents on the Justice portal, and which required collecting information from the member states on what they have as public documents, etc. And I don't know the outcome because they eventually had to vote because some were against it, some were about doing it another time with with a different timeline that one suggested by the commission. So it's not easy. There's a lot of reluctance among the member states, and I'd say what I felt is that it's not related to any geographical area. After all, we've seen that we have Eastern member states very much into the digital dimension of public documents. We've seen more traditional first generation EU member states, so to say, also very much. So it's really different. It's not, I'd say, related to any latitude. It's very different. And the reluctance could be found in some nearby countries and then some faraway countries. So I think personally, I think it's a fascinating area. I mean, if I may, there's a wonderful conference coming up in Strasbourg in September 21st, organized by the ICCS, and the focus is on electronic documents. The Hague is working, I think, almost entirely on pushing for the electronic apostille, because clearly that's the future. That's the future. So there's a lot of efforts to be done. I should also mention that the revision of the EIDAS regulation is ongoing. You might have heard of the e-wallet, and the new president of the commission pushing very much for the future of the digital future of Europe. So that's why the EIDAS regulation is being reviewed. You have a first proposal already available, but if you look into the proposal of the new EIDAS regulation, the one that will be clearly worked out reviewed several times before being approved, it won't be of great help when it comes to public documents, because it's very important to work on an e-identification, electronic identifications, etc., and push it and so on. But because of the traditional, it's almost like family law, when you talk about the formalities of contracts, and it's not something where every country is happy to say, well, all of a sudden the European Union tells us how we should comply with electronic standards if you want to sign a contract for services of good, etc. It's difficult to harmonize, and here it's difficult to harmonize because before the regulation, the EIDAS regulation has a directive. And clearly, directives have certain limits because it's a directive. So it's something that will go through a national process before it becomes law and is applied. So eventually, they had a regulation which unifies certain rules, those apply to everyone. You can't really have nuances in a qualified electronic signatures like, oh, well, you can call it professional, I call it qualified, I call it first level, I call it, no, it doesn't work that way. So we'll see. But I think there's a lot to do, and I hope that you will also contribute to what we're doing. Registers are caught in between because they get, also from South America, from now everywhere in the world, electronic documents. One point that you, for instance, will notice in the commentary is how the e-apostille works. Where you have a scan of a paper copy that is incorporated in the PDF, then is signed. So we have actually one signature that without the signature on the apostille document. So I think this is the scenario. Yeah, it depends on member state, but I've seen that, for instance, I think it's Argentina, they scan it, put it into as a attached PDF, but that scan, it's not necessarily signed. What you get is the signature on the apostille, which is digitally linked, inevitably linked with the original document. It's apostille. You can't sever, for instance, one the other, or you can sever it, but the one will not have the apostille on it. So it's just a scanned copy. So there are different ways to deal with digital documents, but it's pretty much interesting. Okay, thank you.
Okay. Thank you very much, Alexander. That's so very interesting to see how
Interessante. Abbiamo visto
with a number of others, of course, and going into the digital world makes it. Perhaps we have more questions than answers for now, but perhaps I know we're sort of running close to the end of our session, but I might give Katarina perhaps the chance to respond. I don't know if there's anything in particular you wanted to raise from that.
I agree with you. More question than answers. I'm very interested in the review clause of the public documents regulation in this regard, because also, I mean, we see from the many recitals that were mentioned, there are many limits, right? And it seems like the digital versions of the regulation was not the top priority when the public documents regulation was first issued. And I think that this will considerably have to change with the review clause, because as you said, it's the new horizon. That's not the horizon, it's the reality. So it seems that there are two opposite trends in a way. Of course, there is the principle of non-discrimination, that it is a sort of upper general limitation and can work as something that will incentivize the use of public document electronic documents. But I see two trends in a way in the member states. I mean, also the public administration tend to incentivize the digitization of the documents, and then we put limitation in the cross-border use of these documents. This is a very, I mean, in my opinion, contradiction in terms that has to be resolved somehow. So let's see.
Okay, thank you. I'm not sure if there's perhaps we have time for maybe one question from the audience. I don't know if there's anyone here that wants to raise something, or perhaps online as well. Yes, yeah.
Thank you very much, Alexander. It was very, very interesting. I have maybe a question with a more broader scope based on EU law, and in particular on the procedural autonomy principle. Because as you said, thank you. As you said, member states keep a lot of leeway now, and we know that this leeway is mainly based on that autonomy in procedural law, since member states are free to implement EU law. But we also know that the procedural autonomy of member states has limits based on efficiency and equivalence, and we have a lot of case law of the European Court of Justice. So I know that it will still be based on the case law of the European Court of Justice, but these limits of the procedural autonomy of member states could play a role in the development of e-documents and so on. What is your point of view? Thank you.
Yeah, well, the general principle of that limits procedural autonomy are found in the case law, good administration, effective. The single digital gateway, it's something that sets standards at the procedural level. So that's pretty exceptional when it comes to public documents, because they have to comply with the procedure, with the forms, with the access points, etc., that are given in the single digital gateway regulation. Because if we look to the public documents regulation, doesn't really set any commitment in terms of procedure. It doesn't really regulate procedure. I mean, it's really about circulation. And to give you an idea, what is really concerning is the IMI, the statistics of IMI, because it's not just you should answer your colleagues from another member states when they raise a reasonable doubt and seek information to solve the matter. And so that's this part of the regulation sets a procedure, and with some time limits for answers. And statistics say that usually they comply, but not everyone, and someone never complies means that doesn't provide an answer. There's not a lot. I have the latest statistics of an IMI. So the principle of procedural autonomy is retained. I think the regulation, when it comes to national procedures, it's something that tells a lot. But non-discriminatory is exactly one of the principles. So you're free to decide what kind of format you will accept, what the procedure is when it comes to public registers. But certainly one principle we know is that it's not non-discriminatory. And you don't have really a national exception for justifying that exactly the same electronic standards are accepted if it's a national and cross-border users that approaches you, and they're not accepted if they come from someone else. As long as you have common standards, and that's the purpose of the IDES regulation, you can't discriminate even within your procedural autonomy. So do whatever you want. The authority might be a municipality, it might be the government, it might be a decentralized office of the government, it might be entirely in paper on the side, it might be, but as long as you have shared standards, you cannot discriminate. I think this principle, which is not found in the regulation as a principle applying, so to say, to public documents, but tells us something about procedure. And I think this is something that should be developed. Clearly, how can public documents circulate if you have to come to a conference, maybe in Bologna, in Castel San Pietro Tenomé, to see how to deal with them? It should be the commission that embraces, the need of providing clear provisions on electronic documents. We understand the reluctance by member states, but that's the future. I mean, there's an entire pillar of the future of Europe set on digital market and digital documents and the digitalization of everything. And you don't find the courage or the consensus to set standards in the electronic field. This is something really missing in the regulation. I mean, they have to have a section on electronic documents and when they review the regulation.
You should have
It's
similar
unacceptable.
provision as the one we have for certified copies.
I mean, at least non-discriminatory, applications. They could have put it into the regulation. At least a principle where I think it's in the regulation if it's not written in the regulation, but it should have been mentioned. It doesn't say. The only thing we find on electronic documents is without prejudice. Then you can elaborate on what it means without prejudice to the IDES and other regulations. But yeah, so I think it's something where we can provide, some added value, and that's what we tried to do.
Okay, great, thank you. I think, yeah, I hopefully, I suppose a lot has changed since they drafted this regulation in the beginning, and I guess hopefully, particularly with the single digital gateway, that may also make it more obvious that last step, if the output isn't matching the kind of the efficiency of the first stages, it may encourage them to also consider that going forward as well. But okay, so I suppose the conclusion is hopefully we see a bit more encouragement coming from the EU side as well when the revision of the regulation comes in. But okay, I think on that note, we can probably wrap up. I don't know if there's anything else that you wanted to cover, but then we can jump into, we've got the two parallel sessions. I think the one here on the effects of the regulation in light of EU citizenship in 3 languages here. And then we've got the other one on the digitalization of public documents, and that's in the Sala Cielo. So yeah, great. Thank you all. And yeah, we'll see you for the next session.
Sinon, je rajoute 5 minutes. We good. Allez, andiamo. Hello, ladies and gentlemen. We're very happy to be here for this panel dealing with the EU citizenship with the regulation on public documents. So this panel will lead a key discussion on the legal effects of public document regulation in light of the European Union citizenship. To lead this discussion, I have 4 panelists. One is here with us today. It's Nicolas Nord, and you already know him. He's Secretary General of the International Commission on Civil Status. And we also have online 3 other speakers. So you can't see them, unfortunately, but online you can. We have Elsa Bernard, which EU law professor in Lille, and she holds a Jean Monnet Chair Belong. We also have Susanne Gössel, who is professor of private international law at Kiel University in Germany. And finally, we have Martina Melcher, who is assistant professor of private international law at Graz University in Austria. So many thanks to my beautiful panel to be here or remotely with us to address this key discussion. So during this panel, we will explore, as I said, the interplay between the implementation of the public document regulation and EU citizenship regime. A very quick recall of EU citizenship. It's understood here, we are all lawyers by reference to Articles 20 and 21 of the Treaty on the functioning of the European Union. And I can quote very briefly, it covers every person holding the nationality of a member state, and it provides for specific rights. And for us here, the most important, the right to move and reside freely within the territory of the member states. And we know all, but it's, I think, very important to recall it, that the European Court of Justice held that union citizenship is meant to be the fundamental status of a nationals of the member states, so that European citizens who are in the same situation can enjoy the same treatment in law, irrespective of their nationality. Regarding the regulation of public documents, you are all aware here of its objective. And I think I can just recall here the title of the regulation on promoting the free movement of citizens by simplifying the requirements for presenting certain public documents in the EU. So against this background, we observe a gap or maybe a tension within the EU legal order that we would like to address between, on the one hand, the need to ensure the permanence of the personal status of individuals and families which move from one member state to another member states, regarding, for instance, family name, parentage, marital status, and we talked about it already yesterday. And on the other hand, we are all aware of the limited scope and effects of the regulation of public documents, which is also to read in connection with complementary international conventions which are in force in member states, such as ICCS convention, and we will talk about it. The regulations so do not address the issue of recognition of substantial effects of public documents. Hence, there may be here a gap within the EU legal framework, creating legal uncertainties for transnational families within the Union. This is the topic of that panel. And I propose 3 steps to lead the discussion here with our panelists. So first, we will provide for a global overview of the legal effects of circulation of public documents for EU citizens, and we will come back briefly to legal methodologies. In a second time, we will analyze this gap, this tension between presentation of public document on one hand and the regime of EU citizenship. And finally, this is our job of researcher and expert. We will look for legal tools, legal ways for improving the circulation of personal status based on public document within the EU. So let's start with step 1, legal effects of circulation of public documents for EU citizens. So here we will have a quick review, as I said, of the legal effects of circulation of public documents and methodologies. As you know, depending maybe of your background, you are aware of the various legal techniques implemented to ensure the cross-border circulation of family status based on public acts. So very briefly, we can say that it will depend, first of all, from the purposes of the circulation of public document. 3 very quick examples. First, we can ask for the circulation of public document to establish a fact, I'm married, and making it public. I need a registration of my foreign civil status record in my home member state. Second, providing proof. I need to have the proof of the dissolution of my registered partnership issued abroad to get married in another member state. And third and last example, to have a legal status recognized. The parenthood acquired abroad between a child and her same-sex parents, for instance. So you see this cross-border perspective, you have many scenarios which may follow different legal regime depending on the competent forum. So I will ask Susanne. Hello, Susanne. Can you tell us more about these different regimes, including the key distinction, we talked about it yesterday a little bit, between instrumentum and negocium?
Thank you, Marion. It's very crucial to make a distinction between the instrumentum and the negocium. The instrumentum is the document itself that delivers a certain information, for example, the civil status record, or the document issued based on that record. And the negocium, on the other hand, is the legal content that is embodied in that document. That's usually the legal status, for example, the marriage of 2 people. And usually these 2 elements are actually, on a factual basis, interconnected, but legally they have to be separated. Thus, the legality of the instrumentum will be determined by the formal requirements of the authority that issued the document. And the validity of the legal situation, on the other hand, is submitted to the law of the competent forum, including the national private international law rules. And the interconnection between the 2 elements can come from a procedural side, because very often the situation embodied in the instrumentum, so the negocium, can be proved by the presentation of the document, and its content will then be regarded as valid until it's contested. Nevertheless, from a legal point of view, the recognition of the instrumentum is often very easy and based on a formal assessment, and it has to be distinguished from the recognition of the legal situation, which is often based on an in-depth conflict of laws analysis. So to give you an example, if I move from Germany to Italy with my family and present the birth certificate of my daughter, then the Italian authorities in general will make an assessment whether the certificate, which is the instrumentum, is valid, and then most probably will transcribe its content to the Italian records. And afterwards, a presumption applies that the child is legally my daughter. Nevertheless, the content, the negocium, and here the question of filiation, can be contested with the reason that legally the child is not my daughter. For example, because according to Italian private international law, a national rule has to be applied on the question of filiation that regards another woman the legal mother. And obviously, I very much hope that this will not happen, and probably it won't. But its example shows that instrumentum and negotium have to be distinguished very carefully.
Thank you very much for this explanation, Susanne. Now I turn to Nicola. Nicola, how to understand and transpose this legal overview in the field of the public document regulation? And in addition, if I may, could you also provide us with some key elements of comparison with the international legal framework, in particular within the HCCH and ICCS conventions? Thank you.
Yes, of course I can. I'll try at least. First, we'll start with the regulation, just giving you a few details about the regime introduced by that regulation. We talked a lot about it since yesterday, so I'll try to go very quickly. The keystone of the legal regime introduced by the regulation, the main principle is easy to understand. You know, it's free circulation of public documents is established in the European Union area. So it means that the regime appears very favorable to the citizens. Just a few more details. First point, the public documents which fall within the scope of the regulation, as well as their certified copies, are exempted from legalization or any similar formality. And no alternative formality is introduced. Secondly, the practical obstacle of the language is also addressed. It means that multilingual standard forms also introduced in that regulation. So we have models which are appended to the regulation, and they're used to simplify procedures. Therefore, it means that the requested member states should have no difficulty in understanding the public documents submitted to them, and the citizens will not have to pay for the translation of their documents. This is a very important, crucial, practical issue. Thirdly, we already have discussed about it, in cases where the authorities of the requested member states have a reasonable doubt as to the authenticity of the public documents or the certified copy, a control is possible using the IMI system with a direct communication possible between the authorities. These different elements seem to prove that the regulation is a significant progress, a step forward, which should contribute to facilitating cross-border procedures for citizens. However, the effective added value of the regulation may be highly nuanced. Two important limitations appear, and they deserve to be underlined. The first, the regulation does not apply, we mentioned it several times, but it really must be clear for everybody, to the recognition of the legal effect content of public documents. So issued, of course, by an authority of another member state. Consequently, if the act in itself benefits from a liberal regime, the legal relationship that it reflects is excluded. The requested member state is not obliged to recognize the personal or the family situation which are documented in the public document. Second point, the regulation does not apply neither to the question of the probative force of the act in question. Special note concerning the multilingual forms attached to public documents, they are only a translation and they have no independent legal value according to the regulation itself. So the sole purpose of this multilingual form is to enable the understanding of the foreign document to which they are attached. So main objective of the regulation, easy to understand, allow easier processing by the authorities of the requested member states of public documents from another member state, rather than ensuring free movement of union citizens, including the circulation of their personal and family statutes. The emphasis is put on the administrative cooperation between member states rather than on maintaining what we can call vested rights concerning their personal identity. Your second question, comparison with Hague conferences, conventions, and ICCS conventions. Very quickly, the Apostille Convention. So from the Hague Conference, very important instrument, you know it. It's a very famous instrument, establishing also abolition of legalization between the contracting states. Very important instrument, and all the EU member states are bound by this convention. Yeah, very interesting tool, but the main problem is that even if it's significant progress and contributes to simplifying circulation between the member states of public documents, it has the major drawback of continuing to impose a formality, contrary to what is provided in by the regulation for public documents. And apostille means control only of the form of the document, and it does not concern the reality of the legal relationship. Concerning that last point, and the approach is the same as in the European regulation. Relationship between regulation and apostille. You have indications in the convention itself directly. The apostille regime is only intended to operate in a subsidiary way. It means that in the absence of a legal regime more favorable to the reception of the foreign public document, then you will use the apostille. Insofar, we have mentioned it, the regulation sets up a more liberal regime than the convention. It is therefore intended to prevail between the EU member states. They will use the regulation. But according to the regulation this time, it shall not prevent a person from using other systems applicable in a member state concerning legalization or another similar formality. It means that it is possible, it cannot be imposed to a citizen to use apostille, but a citizen can ask for an apostille on a public document. ICCS conventions this time. The greatest success of the ICCS, mentioned several times already, is the convention number 16. You have the title on the PowerPoint. We have at the moment 24 contracting states, and 16 of them are members of the European Union. Multilingual forms of birth, marriage, death are certificates, the models of which appear in the appendix to the convention have been created, and they must be issued when an interested person requests it, when their use requires translation also. Therefore, essentially, when the document must be used abroad. Essential difference, it's Article 8, key rule of the convention. The extracts, multilingual forms have the same value as those used in accordance with the rules of domestic law in force in the state from which they emanate. And they are accepted without legalization or equivalent formality in the territory of each of the states parties to the convention. They can therefore circulate autonomously, and the convention, must admit it, works very well in practice. Modernization was required. This is why ICCS has adopted another new convention, number 34. Again, you have the title, exact title on the PPT. And this text will enter into force in a few days on the 1st of July between 3 states, Belgium, Switzerland, and Germany. And we expect more ratifications soon. Let's keep fingers crossed. Article 5 reasserts the principle that extracts from records issued in accordance with the rules of domestic law of the issuing state have the same value, of course, and they are accepted without legalization or equivalent formality in each of the contracting states. Novelty introduced by Convention number 34. Novelty in case of serious doubt as to the authenticity of the content or the content of an extract issued, the authorities of the state where the document is being issued may request may request the issuing authority to perform a verification of its authenticity or its content, or in case of an error to send to them a new extract. So this means that this mechanism concerns, this is very important, both the form and the content of the document. It goes beyond legalization, which relates, remember, only to the form of the document, and not legalization does not concern the accuracy of its content. This convention, both conventions, they remain applicable, I insist on that point, even between EU member states. As mentioned before, the nature of the ICCS multilingual extracts, Convention 16, Convention 34, the nature is completely different from the one based on the regulation. This means that in accordance with the recitals of the regulation, since there is no overlap between the two types of documents, the regulation does not affect the application of these two ICCS conventions between member states of the EU. So a coexistence exists. And in the practice observed in ICCS, in the frame of ICCS, Convention number 16 is still very often used. We have some details coming from different member states, and that convention is still used between these member states. Thank you.
Thank you very much, Nicolas and Suzanne. We have now the global overview, and based on this knowledge, I think we can now start exploring the gap between the presentation of public documents based on the regulation and the regime of EU citizenship. So to start with, I would like to ask Martina very briefly to make explicit the link that we are working on here between the presentation of public documents and the regime of EU citizenship. Martina.
Thank you, Marion. In fact, besides its limited substantive rules, which have already been elaborated by Nicolas, the impact of the public documents regulation on EU citizens is also shaped by its scope of application. We have already heard a lot of the scope of application during yesterday's presentations, but I would like to highlight certain aspects in regard to our presentation. First, the public documents regulation applies only to public documents which establish one or more facts listed in Article 2, Paragraph 1 of the Public Documents Regulation, such as birth, death, name, or marriage. Consequently, it does not apply to public documents per se, so to each and every public document. Second, it applies only to public documents that have to be presented to the authorities of another member state. In other words, it affects only the cross-border circulation of documents and not the internal circulations. Only to public documents issued by the authorities of a member state. So it doesn't really matter whether the person whose status is concerned or documented, the person whose status is concerned is an EU citizen. What is important is that the document is issued by a member state. Accordingly, documents issued by a third state, like for example, a Californian birth certificate, do not fall into the scope of the public documents regulation, even if they concern the status of an EU citizen. Fourth, only public documents that have been issued in accordance with the member state's national law are covered. This allows an interpretation whereby public documents issued on the basis of international law are not covered. To sum up, so what we want to highlight in this regard, the regulation will apply predominantly to EU citizens. However, it is not limited to EU citizens and does not cover all public documents concerning EU citizens. In this regard, the title of the Public Documents Regulation, which refers to the promotion of free movement of citizens, is somewhat misleading.
Thank you very much, Martina, for this overview. And I turn now remotely to Elsa. Elsa, EU law provides European citizens with fundamental rights such as freedom of movement and the right to respect for private and family life. And we know, and we talk about the case law of the Court of Justice yesterday. The case law provides for a key development beyond the circulation of public documents, and therefore it may demonstrate the weaknesses and the gap in relation with the regulation. Could you elaborate on this issue, please? Thank you.
Yes, thank you, Marion. Yes, you're right. Within the Union legal order, the European Court of Justice is considered as a motor of European integration. And the cases I'm going to talk about, and I know you already talked about them, show that the court actually really is such a motor regarding European citizens' freedom of movement, even though the regulation does not fully promote such a freedom. Indeed, while interpreting the founding treaties, the Court of Justice has stated several times, as you mentioned, Marion, that EU citizenship is intended to be the fundamental status of nationals of the member states. And this status is very important for the court. Why? Because it enables such nationals to enjoy the fundamental freedoms guaranteed by the treaty, including the freedom to move and reside within the member states. Thus, although the rules governing family law or civil status, for instance, are matters that are subject to the exclusive competence of the member states, these member states must nonetheless, when exercising their competence, comply with EU law and in particular with the freedom of every union citizen to move and reside in the territory of the member state, as it is guaranteed by Article 20 and 21 TFEU. For this freedom to be fully guaranteed, national authorities must recognize not only public documents issued by another member state, but also some of the legal effects relating to the contents of these documents, so that the civil and family status of the Union citizen can also be recognized. That's why the Court of Justice, when interpreting the rules related to EU citizenship, does not refer to the regulation, even when a public document issued by another member state is at stake, but prefers to refer directly to the treaty, especially to Article 20 and 21 TFEU. And it did so in this case of Coman in 2018. So I know you talked about it yesterday, so I won't go back to the facts, except to remind you that in this case, the Romanian authorities refused the right to reside in Romania to Mr. Coman's spouse, a US man, on the ground that under the Romanian civil code, same-sex marriage is not recognized, even though it has been recognized under another member state's law, in this case, Belgium. The Court of Justice ruled that, and I quote, this refusal may interfere with the exercise of the rights conferred on that citizen by Article 21 TFEU to move and reside freely in the territory of the member states. Indeed, the effects of such a refusal is that such a union citizen may be denied the possibility of returning to the member states of which he is a national, together with his spouse. In other words, the unhindered circulation of the marital status of the union citizen is consubstantial, with his or her fundamental freedom of movement. The court follows a result-oriented approach by stipulating the required outcome, namely recognition of the status, without any instructions to the member states on how to achieve this recognition of status. The court has also applied these principles in the case of Pancharevo of December 2021. So just a quick reminder that in that case, a couple of women married in Spain had a child born in Spain. The child's birth certificate drawn up by the Spanish authorities refers to both mothers as being the parents of the child. When they applied to the Bulgarian authorities for a birth certificate for their daughter, they were asked for the identity of one mother only, since the model birth certificate applicable in Bulgaria has only one box for the mother and another box for the father, and only one name may appear in each box. The couple refused to mention one mother only, and the Bulgarian authorities refused to issue the requested birth certificate. The Bulgarian authorities did not challenge the authenticity of the birth certificate issued by the Spanish authorities, which named both women as mothers of the child, but they refused to recognize the situation documented therein. In this case, the court requires a twofold recognition. First, it requires the Bulgarian authorities to recognize that parent-child relationship for the purpose of EU citizen to exercise without impediment with each of her two parents her right to move and reside freely within the territory of the member states as guaranteed in Article 21 TFEU. Second, it requires the member states, including Bulgaria, a document which mentions the parents as being persons entitled to travel with the child and which may consist in a birth certificate. Certainly, the court is not directly concerned here with the cross-border recognition of the validity of such parentage from a private international law perspective. Bulgaria is not required to hold the parentage as valid under its own legal system, just like in the case of Coman, Romania was not required to recognize same-sex marriage in its own legal system. Interestingly, from the perspective of the regulation, the court does not elaborate on how the documents, marriage certificate, birth certificate, shall be recognized, but apparently the court requires the recognition of such a document, so the instrumentum mentioned by Susanne, in addition to the recognition of its content, same-sex couple or the parent-child relationship. Therefore, so far, the Court of Justice doesn't seem to need the regulation to protect freedom of movement. The sole interpretation of the rights of the Union citizen gives the court a possibility to intervene, within certain limits, of course, in the area of substantive family law and nationality of member states, even though it is an exclusive competence of the member states.
That was a very didactic and inspiring analysis of the European Court of Justice analysis. And I'm not sure now if we can say that all family law, including civil status, is an exclusive competence of the member states. That's my personal opinion, and I think it's a key question to discuss in the future. But now we need to enlarge our overview and to make comparison a little bit. We will look to the Council of Europe and we will look to national member states. So I will ask Susanne first to some comparison points with the case law of the European Court of Human Rights, and then I will ask Martina some feedback from national courts. Thank you, both of you. Susanne, maybe first.
Thank you very much. The European Court of Human Rights developed a case law somehow parallelly to the Court of Justice of the EU on the recognition of a certain status on several occasions. The cases concerned, in particular, the recognition of foreign adoptions and the parentage of intended parents in cross-border surrogacy and same-sex marriages. And the outcome of the decisions is kind of similar to the Court of Justice of the EU cases, as mentioned. Established abroad has to be recognized as a result, or exceptionally, recognition can be refused due to public policy considerations. The reasoning to come to that result of the Court of Human Rights nevertheless differs, and the obligation to recognize a certain situation stems from the person's human rights, not EU citizenships of free movement. So especially the right to respect for private and family life and the right to marry. And while the court derives from these rights a general right of recognition, she has a more hands-off approach than the Court of Justice of the EU. According to the European Court of Human Rights, national institutions have a broad margin of operation on how to protect and respect the human rights of the people involved. So, for example, in the case of surrogacy, the non-recognition of a parent-child relationship might violate the respect of right of private and family life, as in Article 8 of the European Convention on Human Rights, if the child is genetically related to the intended parents. But a state may meet its obligation from the European Convention on Human Rights if it does not allow a recognition of the status established abroad, but allows the adoption of the child by the intended parents, and thereby, as a result, also establishing a parent-child relationship.
As regards national institutions that are faced with these CJU and ECTHR case law, the public documents regulation doesn't really help us. So these national institutions, they have to resort to other ways to ensure recognition of a foreign status, as is demanded by this case law. On the one hand, if possible, traditional methods are used, such as the recognition of a foreign decision, if the status is put down in this decision, as for example in the case of a judicial divorce, or such as the conflict of choice of law test, which determines the law applicable to a status. If the status exists according to the applicable law, all is well. If it does not exist, for example, filiation is not possible, then there is no recognition. This choice of law test is with regard to registered partnerships. But increasingly, in addition to to traditional methods, also alternative methods are employed by national courts and legislators to come to terms with the EU and the ECHR demands. So, for example, Swedish, French, and German law now provide possibilities for authorities to just recognize or accept a name that was established in another EU member state, as demanded by ECG case law. Furthermore, the Austrian Constitutional Court decided in 2 cases that Austrian authorities had to recognize the parentage of Austrian parents to children born by a surrogate mother in the US and in the Ukraine, respectively. And both decisions are mainly based on human rights reasoning. Recognition in the eyes of the Constitutional Courts seems to be justifiable by a result-oriented logic and argumentation only. So what can be seen is that methodologically, the member states' institutions are struggling.
Thank you very much, all of you, for those key elements. Maybe I can come back to Elsa now to have some critical assessment of that gap or that tension under a European legal policy approach. Elsa, what is your feedback here? Thank you. Elsa, we can't hear you.
Sorry. Can you hear me now?
That's okay.
Okay, sorry. Sorry about that. So yes, I was saying that since the regulation appears insufficient to ensure the free movement of European citizens and their families in the Union, the main challenge is to overcome the underlined inconsistency between the mere presentation of public documents under the regulation and the fundamental status of EU citizenship. In the background of this inconsistency, there is a conflict of interests between states and individuals. On the one hand, states are in certain circumstances reluctant to admit the free circulation of a family status, which could conflict with their fundamental social values when the foreign status is prohibited locally, for instance, same-sex marriage. On the other hand, individuals hold fundamental rights, in particular in personal and family matters. They want the recognition of new subjective rights, and the cross-border movement of individuals is a fundamental right for Union citizens. The Court of Justice, as I previously said, is very protective of these rights. It considers, for instance, that the right to lead a normal family life, both in their host member states and in the member states of which they are nationals, when they return to the territory of that member state, is part of the rights which EU citizens enjoy under Article 21 TFEU, and we saw that in Coman and Pancharevo. This inevitably leads to cases of delicate transplants of family models, as national conceptions are very diverse in this area, even on the limited scale of Europe. States may be reluctant to such recognition since they consider it could have an adverse effect on public policy and on their national identity. In the Coman case, for instance, a number of governments considered that even on the assumption that refusal to recognize same-sex marriages concluded in another member state constitutes a restriction to Article 21 TFEU, such a restriction is justified on grounds of public policy and national identity. And this point is very important because according to the treaties, according to Article 4.2 of the TEU, the EU respects the national identities of its member states inherent to their, in their fundamental political and constitutional structures. For the Court of Justice, on the contrary, the concept of public policy as justification for derogation from a fundamental freedom must be interpreted strictly, with the result that its scope cannot be determined unilaterally by each member state without any control by the European institutions. And for the court, it follows that public policy may be relied on only if there is a genuine and sufficiently serious threat to a fundamental interest of society. This strict interpretation of national public policy also appears in the Pancharevo judgment that I mentioned earlier. In that case, the court held that the obligation for a member state to issue an identity card to an European citizen whose birth certificate issued by the authorities of another member state designates as a parent two people of the same sex does not undermine the national identity or does not pose a threat to the public policy of that member state. Indeed, that obligation does not require the member state, so here Bulgaria, to amend its domestic law allowing the parenthood of persons of the same sex. These cases show that when the rights of the Union citizens are at stake, especially their freedom of movement within the Union, the court seemingly awards little consideration to the public policy of the member states or to their national identities.
Thank you. Thank you very much, Elsa, for this very insightful analysis. And I would say we really need to be careful here because we feel the sensitivity of the topic. And as academic, I see these actions with practitioners is very important. We are talking about civil status, citizenship, family, and yes, we need to be careful and open to discussion. And this is the place here to do so. So thank you very much, Elsa. We can now move forward and look for ways of improvement. As I said earlier, we are here experts and researchers, and we tried to look to the future and to propose today some way of improvement. So there are different legal methodologies based primarily on private international law, key to follow this path, more effectiveness of the European citizenship based on inter alia civil status circulation. And we will need also here the precious experience and acquis of the ICCS. And we are very happy and honored to have Nicolas with us today. So three main fields of proposals. So the first technique I have in mind is the famous, very famous rule of recognition. So Martina, can you give us some elements on that possibility of that rule of recognition?
Thank you, Marion. Before answering your question, I would like to first shed some light on this famous rule of recognition, as it is often used as a term, but rarely explained. In fact, such a rule has been amply discussed in the literature. These elaborations all describe the rule of recognition as a method to ensure the continuity of a civil status that has been established abroad. Explanations and definitions vary in details. As such, this rule still lacks precise overall accepted criteria regarding its effects and preconditions. It might be helpful to link the rule of recognition with the automatic recognition of the authenticity of a public document. This would provide a link between the recognition of the instrumentum and the negotiation. The same has been done with regard to the recognition of the content of judgments and certain public instruments in the context of the Brussels 1 bis regulation, the Brussels 2 bis regulations, and the EU successions regulation. In some member states, for example in Austria, this method, as it is regulated by respective domestic rules on the recognition of foreign judgments, has already been extended to non-judicial decisions and other public documents. Also, the new Brussels 2 regulations provide for a similar extension to authentic instruments and non-judicial agreements on legal separation and divorce. However, the European Commission already suggested the recognition of the content of public documents alongside the mere recognition of the document when preparing the public documents regulation. Namely, in its green paper, the Commission had proposed automatic recognition, meaning that each member state would have to accept and to recognize on the basis of mutual trust the effects of a legal situation created in another member state. This advance was strongly rejected, and now 2 paragraph is not required to recognize the content of any foreign public document. Do the recent judgments of the CJU and possibly also the ECTHR, the European Court on Human Rights judgments, give hope that the suggestion of automatic recognition might not be so strongly objected anymore? The European Commission certainly remains willing to go further by pushing for mutual recognition for family relations in the European Union. An expert group on the recognition of parenthood has been set up. And as we have heard, the member states struggle methodologically to comply with the requirements imposed by the case law of the European Court of Justice. In any case, this way to go forward should not be rejected straight out of hand just because it has been rejected some time ago. Maybe appropriate and well-balanced limitations to protect national identity concerns might prove helpful to further an agreement. For instance, and this is important to keep in mind in this regard, only 13 of the 27 EU member states have at the present time extended marriage to same-sex couples. And among these 13 member states, only 7 provide for the automatic parenthood of the wife of the biological mother of a child. So this is an important issue that cannot be neglected when talking about a rule of recognition.
Thank you very much, Martina. I fully agree with this analysis. We have here as a background the motto "Unity within diversity" in the European Union, and we understand that the comparative law approach is a very important element to go further in the European integration and the development of free movement, including civil status. Another technique may be the recourse to substantive law. And here again, of course, the background of comparative law is important. So substantive law, but with a cross-border nature. Could it be a feasible solution to introduce, for instance, uniform public documents in EU law to regulate more smoothly the free movement of families within the EU? I will turn to Martina again, and also to Nicola. Martina first, and then Nicola. Thank you.
Indeed, Marion, the creation of uniform public documents, which means substantive harmonization, might accelerate the circulation and is also convincing in terms of efficiency. It could provide proof of its content, which may only be rejected in case of full proof to the contrary. The European Certificate of Succession could serve as an example, except that unlike the European Certificate of Succession, a uniform public document should be a complementary document. It should not be a complementary document only, but should replace national public documents to create more efficiency. However, any uniform instrument presumes a harmonization of requirements, and this is the greatest advantage, but also the greatest challenge. Among other issues, one would have to determine which institutions, which authorities may issue such uniform public documents. They should be public authorities that comply with preset formula criteria and act within their competence. To determine their competence, a rule similar to the rule on jurisdiction could be established. A rule that ensures a close link between the matter at hand and the public authority. For example, a birth certificate could be issued by the authorities of a member state where the child is born, of the member state whose nationality the child has, or of the member state where the child is where the child has his common habitual residence. Actually, the EU expert group on the recognition of parenthood discussed the establishment of such a European certificate of filiation. However, from a political acceptance point of view, one must keep in mind that the European Parliament, as well as certain legal practitioners, especially notaries, have already repeatedly, but unsuccessfully, suggested that the European Commission propose authentic. Also, it still does not cover the establishment of a European certificate just yet.
In addition, I think to circulation of public documents within the Union, the creation of an act making circulation of citizens between member states easier is also conceivable. For example, the International Family Record Book created by the ICCS Convention number 15 could be a source of inspiration. And that family record book, well, it's a model in an annex to the text of the convention, and it is composed of a multilingual form of marriage certificate and multilingual forms of birth certificates. And it allows persons concerned to register in contracting states civil statutes events concerning their family. And such an instrument will always be up to date, whatever the country in which the persons are. The convention, unfortunately, was not very successful. In fact, only 4 states have ratified that instrument: Greece, Italy, Luxembourg, and Turkey. The text is in force, yes, but without the influence that was imagined at the origin. Essential reason for that situation, it's the exclusivity of the model introduced. National record books can no longer be issued in the contracting states. It's too intrusive. We made an inquiry in the frame of ICCS, and the register's attachment to the national documents was noted by most of the registers. It means what? It means that at the EU level, however, the solution could then be to consider such a record book as a model, but to leave an option. Leave an option to the citizens. They would have the choice between the national model and this international record book, following the general principle of party autonomy.
Thank you very much, Nicola and Martina, for those development. And it's my personal opinion, but I would really like having a European family record book. And if we take the question the other way around, I think this could also help citizens feeling more European. Okay, that's my personal opinion, but voilà, it's important for me to share with you. So let's finish with the third proposal. Based on the political reserve and uncertainties you talk about, you all mention here, we could still consider other options, maybe more self-restrained option. And here I will give the floor to Susanne first, and then to Nicola again. Susanne, please.
Thank you. What I would propose is to perforate the independence of negotium and instrumentum, which I mentioned earlier. I believe there should be a substantial impediment to challenge a status that has been validly registered or transcribed in the National Register after a certain amount of time has passed. So, for example, if a status has been validly registered and the person has lived under that status for, let's say, 5 years, to give you a number, had a legitimate expectation that the status continues to exist should be protected. And some member states already know rules pointing in that direction, most famously the Dutch doctrine of fait accompli. And so I'm thinking of a rule that does not allow a challenging or rejection of a status that has been validly registered and where the persons concerned lived under that status in good faith and were accepted as such for a certain period of time by national authorities. And as I said, maybe 5 years might be such an amount of time. And such a rule would provide legal certainty regarding the durability of a registration and thus also enhance the portability of a status and the trust put into public documents, public authorities, and their registrations. And at the same time, it would encourage the competent authorities to scrutinize foreign status in depth already before its registration.
Thank you. Nicola, then with the point of view maybe of the ICCS.
Yeah, I think that the situation at the moment is not very satisfying concerning a relationship between the different instruments, ICCS conventions and regulation. And more satisfactory interplay is needed, and I think that we can make some progress. Why? Because there is an agreement. If you can just change the PowerPoint, an agreement, it's not a very famous one, but it's still in force between ICCS and what was still the Commission of the European Communities. And I think that we have the point 3 of that agreement on the PowerPoint. It's very important. You see it. The Commission may recommend, so the European Commission may recommend to the member states of EU now to sign and ratify the conventions prepared by the ICCS on matters submitted to it, or to accede to these conventions. ICCS may invite the Commission to recommend to the member states of the EU now to sign and ratify any other conventions adopted by it or to accede to them. So based on the lessons learned from the effective operation of Convention number 16 over several decades now, Convention number 34, once into force in a few days, could then be used to allow genuine cooperation between EU member states with the same tool that could also be used in the relations with third states. And this solution would make it possible to just simplify reasoning to avoid a complex coexistence while having a modern and an efficient instrument. It would be, of course, a major development for European and international civil statutes and clear benefit for citizens. They could easily prove their personal status in EU member states, yes, but also in third states, which would join this system. Of course, also conceivable, for example, the regulation perfected in the light of the experience of the ICCS conventions could apply between member states, and Convention number 16 or number 34 could be the preferred instrument in relations between member states and third states. It means that the ICCS conventions could serve as a basis for the regulation, which could make some improvements on some points, specific points, as it has been done already with various Hague conventions. Final essential remark must be made. Citizens' mobility is not confined to the EU. Having recourses to instruments which are likely to be applied also in relations with third states has many advantages, in particular that of not having to manage the plurality of legal regimes. Examples: Switzerland, Turkey, Moldova, countries of the former Yugoslavia, they may be given. These states are party to several conventions of ICCS, Convention number 16 especially. And one of the obvious justification is for them the desire to allow a simplified circulation of civil statutes documents in relation with the EU member states, their neighbors. The adoption of the ICCS texts by the Union in one way or another would therefore be an excellent solution in this respect. If these third states decide to be bound by the new convention, Convention number 34, this is already the case for Switzerland, this text could be a precursor of such an approach.
Thank you very much, Nicola, and thank you very much all the panelists here for this very high-level discussion on some very concrete challenges faced by the implementation of the public document regulation in the EU legal order, which is by essence, and it's important to recall it, an area of free movement of citizens and families as part of the international order and international community. Thank you very much, all of you. Yes, if some of you have questions, we are open to discussion, of course.
Logicamente sulla base dell'ordine del giorno. Sì, prego.
Good morning. My name is Gregor Christander from the University of Graz, and I would like to discuss your options that you presented as recommendations how to improve circulation of public documents with regard to the Pancharevo case. So you said the protection of legitimate expectations. Is that an option that is applicable to a child that has born only recently? Maybe not. I don't know, but I would be interested in what you say. And with regard to your second option, where you say there should be uniform public documents, I wonder if we refer to the European Certificate of Succession, the regulation tells us what law is applicable to the succession, and this certificate is issued on the basis of this law applicable to the succession. With regard to civil status, what is the law applicable? So does this mean that a European birth certificate, for example, is issued on the basis of Bulgarian law, which means that this conflict that exists in the case of Pančarevo does not even arise, because the Spanish authorities would issue a birth certificate according to the rules of Bulgaria and not according to their own rules. But I would be interested in those implications with regard to the second option. And with regard to the first option, I think that's the only option that really works, but obviously it evades the rule of recognition, but it evades national rules. So the values of Bulgaria are just not respected, because Bulgaria would have to say, we recognize automatically what the Spanish authorities say. If this is a Spanish birth certificate, we recognize it and do not analyze it in the light of our values, which is rather difficult, I think, to ask. But in a way, the European Court of Justice requires them to do that, at least to the effect of not interfering with the free movement in the European Union. So I wonder, and this is an implication that has not been discussed already in the Pančarevo case, would this mean that this child becomes a citizen of Bulgaria? Because we know EU citizenship is always linked to national citizenship of a member state. And does the Court of Justice require Bulgaria to recognize that this is a citizen of Bulgaria, with the consequence that it enjoys all freedoms of a EU national or EU citizen? Yeah.
Thank you very much for those diverse reflection, comments, and question. Maybe just for the last element, and I will give the floor to my panelists. Also, I took some notes to give the floor to different speakers. Just maybe very quickly on your last point, the Bulgarian nationality for the child in the Pančarevo case. I think, if I have everything in mind, that there is a difference between the opinion of the Advocate General and the ruling, because in the ruling, the prerequisite of the reasoning of the court is based on the fact that the child is a Bulgarian national. But I'm not sure. Maybe I see Elsa saying yes. So, voilà.
Yes, because that's
so
actually what
very important. Okay, Elsa, you want maybe to add something?
No, yes, no, you're totally right. And this is actually what the national jurisdiction said in the preliminary ruling. So the court considered that it's true. She's a Bulgarian, and this little girl, and so she's a European citizen, and that's it. But it's true that Advocate General Kokot doesn't follow the same reasoning, but.
Yes, so that's the first point. Maybe if we go back to the beginning of your question and comments, dealing with the expectation, I think, Susanne, maybe you're well placed to respond a little bit.
Thank you. The answer is pretty quick. You are right. The general requirement is that legal expectations have to be established to be protected. And usually legal expectations need a certain amount of time where a person lived under a registered status to create the trust, the expectations, and the validity of the status. So a newborn which has been registered does not comply with those requirements.
Thank you very much, Susanne. Dealing with uniform documents, maybe Martina, you want to say something? I have also some reflection on the interplay between applicable law and uniform instrument, but maybe you first of all, Martina, and maybe Nicola also.
Thank you, Marion. Yes, I think this is a very valuable question and a good question to ask regarding the applicable law. Meaning, if a public document is issued, if a uniform public document is issued, one must determine the applicable law to the underlying status. I think as long as there is no uniform regime regarding the applicable law, as exists with regard to the EU succession regulation, we would have to rely on national laws, and that would each member state would apply their own law. This is problematic, and this is an important issue, an important point why the uniform public document approach still has a long way to go to actually work in practice. Yes.
Nicola, do you want to add something?
Yes, just a few words. I know it's always very difficult based on the ICCS experience to create a uniform tool. It's much easier. You can check the success of our conventions. It's much easier to organize circulation of documents. So I think that, of course, several options must be considered, but always facilitating circulation, well, it's less intrusive for the states, and so it works much better.
Thank you very much. Maybe just very quickly on the legal technique to respond to your question. If I can summarize, the issue with your question is the interplay between the applicable law to the situation and the uniform law as a legal basis for the circulation of the situation. And I would say that in any case, we have always these two steps. So we always have the applicable law to the creation of the situation. For instance, the child is born in Italy or in Spain, and there is the applicable law based on the Spain legal system to respond to the question of parenthood, for instance. And then we could use a uniform status record, for instance, so based on a uniform law applicable only to cross-border situation. And in that way, I would disagree with your point saying that in the Panchavero case, it would mean that the Bulgarian law will be applicable, because as you can see in my example, the home state could fully be and would be and is in that case the legal order of origin which created the situation. So Spain, sorry. Okay, but it's true. Those are very valuable comments, and thank you very much for jumping into the discussion, because here we are making proposals, and they are of course open to discussion. Do you have other question or comment? Yes, please.
Thank you. I just Marzia Ghigliazza, yeah, Marzia Ghigliazza from Italy. I'm just introducing actually an argument and a question, if you want. We are dealing here about circulation of status, and I am dealing since a long time the problem of names. Okay. I always wonder, obviously, if I refer, I mean, we can refer if we want to have a common base to Grunkin and before to Garcia Vello, if you want, and to all the ICCS. And when I was thinking now, for the great answer you gave, actually the same problem that you arise that we have with the with Panchevo or with Common, we have, if we think of the Monaco Convention of ICCS, dealing actually with the law applicable to the name, but not to the situation of creation of name, if it comes from filiation, if it comes from marriage, if it comes from whatever. And Antalya has not been, I mean, we have just, I think, unless my mistake, Portugal who signed it. So we don't have a real instrument today to recognize names. I am wondering why the question of name that is so strictly bound to identity is dealt, if you want, with a second line tension, both from the Court of Justice and human rights court, not to talk about national systems, and even less if it is dealt with adults, meaning that we have cases where we got open decisions just because they were bound to a child. But it is as if nobody's really considering that precisely the same law principles we are discussing for huge arguments like same-sex marriage or filiation are precisely identical for the name of a person. And on purpose, I use person and not minor or adult.
Thank you very much. Maybe I will first give the floor to Nicolas, and I will give maybe some personal feedback. But your experience here is very interesting, and thank you for sharing.
Yeah, but I have not much to say, but just to regret that our conventions are, especially the last that you mentioned, not really successful. But it's just a crucial issue concerning sovereignty, and I have the feeling that each time that we're trying to just discuss to put the question of name on the agenda, everybody is a little bit scared and wants to preserve the national leeway. So that's the main problem. I don't have an answer concerning the European Court of Human Rights, but that's my personal experience in the ICCS frame.
I would like to add maybe a feedback just from France. So it's just a little feedback, but it's true that we recently changed the law regarding name based on the development of Garcia Avelo, Grünkill-Poll, and nobody talk about it. I discovered it because I had to make research for a national report, and I discovered that. I was ashamed. As a lawyer in EU law, I was not aware of this change. So it's difficult to say if it's because it's sovereignty, so the lawmaker did it very discreetly, not to create a sensitive debate, or maybe also because he's not fully aware of the importance of that topic. It's difficult to assess really that point. So voila, it's just a French point of view, but there is a huge room for research, development, and exchange. So to be followed. Thank you very much. Maybe we will conclude the panel since we are a little late. We can go on with the exchange during lunchtime for those we are here, and we are very happy. And online, thank you very much for the audience online, and thank you very much for our panelists online also, and of course to Nicolas for this fruitful discussion. Thank you very much, all of you, and bye-bye.
You're ready. It's my honor to be moderator of that very distinguished panel. We have great experts on the table. I will just introduce them to you and then give them the floor. I think that the best way is to concentrate questions at the end of the panel so that you can easily discuss with each of our speakers. The first speaker is Francesca Maoli, coming from the University of Genoa, who is a postdoc research fellow and adjunct professor. And the second speaker will be Fabienne Jo, who is a very famous French professor at the University of Paris-Saclay, Versailles. If I remember well, who is can be considered as, I think, the leader of that panel. We are here due to the investment of Fabienne. And the third speaker will be Guillermo Palau Moreno, who is a catedrático a la Universidad de Valencia, and who is also involved in the ICCS, who is a strong support of ICCS. So I will immediately give the floor to Francesca. Just one word for one of our colleagues who started to work with us, Laura Carpaneto, also from the University of Genoa. She cannot be here with us, but I think that we have we're thinking on Laura today also. So Francesca, the floor is yours.
Thank you. Okay. Thank you so much, Nicola. And I would also like to thank you to me be here with you today. And our panel is concentrates on possible discussion and proposal for a global framework in the circulation of public documents, also as concerns third country nationals. And we will address it from a different perspective. And I will concentrate and it was a sort of introduction on the need for a European common framework for third countries. And of course, we have already addressed many aspects related to the issue of circulation of public documents on many points of view yesterday and today. And we have understood that while the EU certainly fosters and protects the right of free movement of its citizens, which is a cornerstone of EU law and the EU area of freedom, security, and justice, the EU is necessarily concerned as well by the reception of third country nationals in the EU. And of course, in both scenarios, intra-EU movements and migration issues, there is the need to ensure the continuity and the portability of family status. And in particular, with specific reference to third country nationals, the implementation of the European migration rule, as we will also see in the following presentations, requires the resolution of civil status issues on which there seem not to be a common approach so far. Many instruments, but sometimes, most of the times, they present themselves as quite fragmented. And at the same time, we know that you as with the regulations of 2016 that we have examined in these days, but there are some fragmentations as concerns the documents released in third countries with the many aspects that we have seen. And so the objective today is to foster a common legal framework for public documents on civil status, and this will also reinforce the coherence of EU migration law. And so I made a little map of the thank you. I made a little map of the analysis on what I would like to discuss with you today before leaving. I think we have some issues. Thank you so much. And on what I would like to discuss with you today, but let's go into it and not to take too much time. And of course, we has this voice behind, I don't know why. Of course, we have examined how personal family status circulation is relevant for the application of EU law. And we know that even if the EU does not hold competencies in the field of substantial family law, of course, the latter assumes relevance when the existence of a family tie is a prerequisite for application of rules of EU secondary law, which is true in the first instance for the free movement of EU citizens and mainly for family reunification. As we know, this is disciplined by the Directive 2004/38. And in this regard, mainly the ECJ has underlined how the refuse by a member state to recognize the family status of a EU citizen may cause important drawbacks. And so the ECJ has construed this principle of functional recognition. I will not dwell on the Coman and Pancharevo cases, which are briefly presented in the next slides for obvious reasons, because they already been examined by highly qualified speakers in these days. But indeed, family status, personal family status, is a prerequisite also for application of other rules of EU secondary law, as concerns the reception of third country nationals. Just to make a few examples, the protection of unaccompanied children, which is partially provided by the Return Directive, often depends, for instance, on the proof of age and requires some certain family members. At the same time, family reunification as a right of third country nationals, I'm speaking about the Directive 2003 right now, depends on the identification of marriage and parentage connections, of course. Just to make another example, the Dublin regime, Dublin III regulation, the existence of family ties is sometimes a prerequisite for identification, for the determination of which state is competent for asylum applications. So this means that sometimes, a lot of times, reception depends on the portability of personal and family status. And here also the importance of public documents. I will skip common and transferable. So country nationals are affected by the circulation of civil status documents and other documents that incorporate personal and family status in the migration context. And of course, we know that public documents assume a certain and central importance in this regard for all the translation and the trust issues that we well know. I know that the recognition of public documents is not always decisive as concerns the substantial effect of a personal and family status, but nevertheless, the presentation of a document is often a prerequisite for the legal relationship to produce its effects in the host or receiving state. And in this, know that there is an existing international legal framework. I will go fast also in this regard because, for example, also this morning, Nicola Nord and others have dwelled on the 1961 Apostille Convention and on the instruments provided by the International Commission on Civil Status. But just to say something about the Apostille Convention, it's a successful instrument, like many instruments fostered by the Hague Conference. And it demonstrates that already a few decades ago, even before the European community did not hold competencies in this regard, the Hague Conference was already concerned because the issue was already on the plate. And in this, the Apostille Convention is an innovative convention because it eliminates a lot of administrative burdens, not completely, because of course it does not authenticate the content of the public document and it does not determine a complete elimination of the administrative formalities, of course. And it is also interesting to notice that the Apostille Convention, the work of the Hague Conference on the Apostille Convention, is a consequence of a request of the Council of Europe to the Hague Conference to work on the matter. And as concerned the International Commission on Civil Status, we have examined main aspects of this, but it is also important to underline that the International Commission is the only international organization dealing exclusively with the objective to facilitate international cooperation in civil status matters. It's a specialized organization with a great expertise in the field that has been built over the year. And one of the examples, if not the only, is the Convention number 16. And also, of course, this is not the only one, also the Convention number 34, which you spoke about this morning. And in this context, we have the regulation, the EU regulation 2016, that has many advantages and disadvantages. In all, we can speak of a lot of aspects related to this regulation, but all in all, we can notice that the regulation has reached a minimum harmonization, if we can, or a minimum unification, because there is a great downsizing if compared with the original plans of the European Commission while building the proposal for a regulation. And in this, and in relating with the international legal framework and international instruments, the regulation does not solve at all fully the fragmentation of the existing legal framework. We see in Article 19, when we can read that the regulation does not affect the application of agreements to which member states have already parties and in the part on which they do not affect relationships between member states. And there is also the possibility for member states to conclude new agreements in this regard. And in this fragmented context, the idea is to dwell a little bit more on the global appeal of the European Union, a global appeal that the European Union is already exercising in other fields and can also improve the synergy with all their international actors in these specific fields. Because if the European Union exercises this global appeal in cooperation with other international actors, it could reinforce the coherence also not only of EU migration law, but the overall legal framework. And this also can be inspired by human rights consideration, because we know, for instance, that also the European Court of Human Rights has said that when possible, a family status shall be ensured portability unless the limitation is justified by legitimate considerations. But at the same time, the EU has instruments in this regard as well, because we know that the EU Charter must be interpreted in accordance with the European Convention. But at the same time, differently from the European Convention, the Charter does not have a territorial jurisdiction clause. Like we read in Article 5, paragraph 1 of the Charter, the application of the Charter derives from the applicability of EU law. So the defining issue here is not the territorial applicability or the extraterritorial action undertaken by the EU or its member state, but rather than the scope of application of the EU competencies in the field. And we can combine it also with the principle of the parallelism of competencies. And going towards the end in how can this global appeal be exercised? We know that in the field of judicial cooperation in civil matters, for instance, the legal partner of the EU is the Hague Conference of Private International Law. So there is a potential here for a concerted activities, and we are already seeing this potential because we know that at least in one specific matter, the European Union is already working in parallel with the Hague Conference and speaking about, on the one hand, the parental surrogacy project of the Hague Conference as concerned parentage, of course, and the possible future Commission's proposal for a regulation on the recognition of parenthood between member states. There are already two parallel situations, and on the other hand, we know that the global instrument is possible because it already happened other time, like for instance with the 2090 judgment convention of the Hague Conference. And at the same time, it will be interesting to integrate this concerted action with the specialized expertise developed by the International Commission of Civil Status, of course, which is a creator and a promoter of innovative methods that can be used in a more global perspective to facilitate the circulation and acceptance of civil status documents worldwide. So for this, I have concluded, and thank you very much for your attention. Thank you.
Thank you very much, Francesca, for your interesting contribution. Of course, I fully agree with the last proposal. I think that we need to have a real agreement concerning these kind of questions. Perfect respect of the time limits. I think you're the first speaker since the beginning of the conference to respect the time that has been given. So I immediately give the floor to the PowerPoint. The floor to Fabienne Jo, that I have already introduced and who will go on now.
First, I want to thank the organizers of this conference. It's a great pleasure to be here to talk about civil status. I also want to thank the whole team very warmly, Francesca, Guillermo, and Nicola. Okay. Have been great. It was very easy to work with them to prepare this panel. My presentation is a little bit out of step with the general theme of this conference, as I am going to deal with people who have no civil status documents or no valid documents. The subject is very broad. I will try to be as brief as possible. The subject is approached differently in the different member states. It is not very coherent when it comes to people entering and moving around the European Union. That is why I suggest that the EU has to act in this field. What are we talking about? Undocumented means without documents or without valid documents. This clarification is useful because the term is also often used to refer to people who are staying in the European Union illegally. But it's not my point. I will speak about people without documents or without valid documents. Why peoples are undocumented? There is many reasons for that. Lack of birth registration, lack of recognition of the civil status document, loss of documents during the migration process, and also deliberate destruction to erase the traces. You can imagine it affects a lot of people. Why action is needed? There is a fundamental right to a legal identity. It is enshrined in Article 6 of the Universal Declaration of Human Rights. Everyone has the right to recognition everywhere as a person before the law. And to be a person, you have to be identified. It is also enshrined in Article 16 of the International Covenant on Civil and Political Rights. Being documented, having documents, is a prerequisite for exercising all other rights. More recently, the United Nations Sustainable Development Goals for 2030 states in its target 16.9 that we have to ensure legal identity for all, including through birth registration. The problem is also addressed in the Convention on the Right of the Child, in the Global Compact on Refugee, and in the Global Compact for Migration. But to act, one must understand the current situation. Let's first look at the lack of registration. Currently, 237 million children under 5 years, it's a statistic from the UNICEF, under 5 years old worldwide are currently without a birth certificate. Many people do not know the date of birth. Why? There are some cultural, some economical, some technical barriers for that. Sometimes people do not need documents for their daily life. They do not see the need for civil status. In other cases, access to the registration center is very complicated. They don't go registered. On other cases, there is some discrimination on gender, on ethnic, on nationality. I will give some examples. In some countries, it is fathers or another male family member who are assigned the legal responsibility to register the child's birth. If the father does not register the birth, the child may go unregistered. Another example, it's in the Republic of Korea. The current system does not allow for birth registration when both parents are foreign nationalities. In some cases, civil status is synonymous with danger. In Rwanda, for example, during the genocide in 1994, birth certificates were used to identify the ethnic origins of children and adults for extermination. In Eritrea, registers were used to identify young people who were likely to be recruited into the army. These situations are not acceptable. If documents are necessary to make the right to identity effective, then all states should be helped to set up effective and non-discriminatory civil registration systems. Progress has already been made. There is numerous reform of civil registration laws in the world. There is numerous programs to assist states in order to establish efficient civil status services. What are the tools? First, we can see at the action of the UNHCR. We can also try through the development aid. For example, in France, there is a recent roadmap on international action in the field of civil status from 2021 to 2027. This roadmap highlights three objectives: increasing international and European mobilization in favor of civil status and legal identity, two, reinforcing the consideration of civil status in French public development aid, three, raising awareness on the issues of civil status and birth registration. The most helpful tools can be innovative technologies to overcome the different barriers I mentioned before. Mobile phones, biometrics are often now used to help registration. Let's now have a look to the lack of recognition of civil documents. Recognition of documents is often refused on the grounds of unreliability of civil registration systems in states of origins. The argument of fraud is also frequently put forward. In the paper, I analyze the law and case law of different member states, but I have not the time here to develop. It is interesting to note that the International Commission of Civil Status in 2000 has made a study of the compatibility with the European Convention of Human Rights of the different legislative taken by states to combat with respect to civil status. Recent researchers from different PhD have also looked at this problem, its compatibility with fundamental rights of these different measures taken by states with regard to fraud. But there is still some room biggest room for improvement. The better the foreign civil status service are, the easier it will be to recognize the document issued. But there is also a need to find palliatives to the lack of reliable documents. This could be the role for the European Union. The first question arises: is the European legislator competent for that? From my point of view, the answer is clearly yes. If not, I wouldn't have been there. First, we can count on the development program, development aid. We have a legal basis for that, Article 208 of the Treaty on the Functioning of the EU. It is interesting to note that in the Valletta summit of 2015, the European Union decided to cooperate with countries of origin of migrants in order to address the absence of the identity document. After that, several African countries contracted with the Fund for Africa, the Trust Fund for Africa, with private or semi-private entities in order to set up biometric-based identification systems and documents. Another basis for the action for the European Union is to be found in the area of freedom, security, and justice, with Article 67 of the Treaty of the Functioning of the EU, and precisely on the basis of Article 78 to 80, which sets the common policy on asylum and on migration. And the European has competence for that, but how can act the first, and Francesca has already addressed this point. The European Union can cooperate with the existing international organization. She mentioned the Hague Conference of Private International Law, the International Commission on Civil Status, but it would be also interesting to cooperate with the UNHCR and with the UNICEF. The European Court of Justice can also play an important role. In other areas, the court was an important motor to the development of the legislation. Regarding our topics, through the best interest of the child, the court can have an important role in the area of asylum or migration law. Already in the case TQ, I don't know if it is well known here. It's a case for the ruling was from the 14th of January last year, 2021. The court has dealt with the EU Return Directive, and it was involving an unaccompanied minor, children, and the claim for international protection was rejected. But the court then said that it was important before to order the return of the child to verify if there were some help in the country of origin of the children. If not, it was not possible to decide to order the return. Of course, we can also expect we can also hope that the European Union act with regulation and directive. It can do it in the field of asylum or migration. I already said on which basis. And there is also some best practices given by the fund or by the European Union Agency for Asylum regarding some topics I will now address. And I come now to the concrete actions that are needed. I will give only a few examples. First, the age assessment, and second, the reconstitution of civil status document. Regarding the age assessment, doubts may exist regarding the age of unaccompanied minors that are seeking protection in host country. Fraud is often alleged to the detriment of the best interest of the child. Many states, all member states have procedure for this topic for age assessment. And some of them are still based on bone tests, on medical examination. Many are now based on interview with the childs or social team. But regarding the best interest of the child, and according also to the already existing asylum law, minority should be presumed, and when it is not possible to determine the child the age with sufficient certainty. But often the solution is presumption of minority remains theoretical, and in practice, the authorities conclude easily that the child is over the age of majority. In this regard, an effective rule should be implemented by the European Union. The European Commission has already played an incentive role. For example, the European Commission in 2018 have noticed to Bulgaria that their rules are not good enough. And Bulgaria adopted amendment to the law on asylum on refugees, which introduced modifications to the assessment procedure in order to implement the best interests of the child. And the second example is the reconstitution of civil documents, of civil status documents. In France, for example, we have the French law provides that the French Office for the Protection of Refugees and Stateless Persons is authorized to issue to refugees and beneficiaries of the protection, of subsidiary protection, or stateless status, the documents necessary to enable them to carry out the various acts of civil life, or to have the provision of domestic legislation or international agreements concerning the protection applied. In particular, and that's wording of the law, the French law, in particular the Office for the Protection of Refugees and Stateless Persons can issue documents in lieu of civil status certificates. Regarding the reconstitution of civil status document, it is interesting to look after the UNHCR. In 2002, the UNHCR has set up a database containing various informations on the people seeking protection. This database, named Progress for Profile Global Registration System, stored data locally. But now there is another system named PRIMS, for Population Registration and Identity Management Ecosystem, that consolidate all these different local database in a single database. The idea is that PRIMS, this only one database, will be interoperable with all IT systems used by governments or by organizations such UNICEF. Based on these different experiences, the European Union should recommend the establishment of new documents to comply with the fundamental right to have an identity. Last but not least, circulation of civil status documents should be addressed. The European Union framework has already been addressed, but it is important to note that it concerns not only EU citizens, but it concerns also third country nationals. Thank you for your attention.
Thank you very much. 20 minutes. Impressive. Of course, I think that if you want to deal with civil statutes questions, such issues must also receive a clear answer, and we cannot just say we have a regulation concerning public documents and we don't care about the other parts of these issues. And I think that's one of the main questions, of course, and we have already discussed with some of you before, is the question of the competence of the EU. What is the legal basis? And maybe it will give ideas for organizing a new conference about that question, just to clarify it, to know exactly if there is a legal basis and which one can be used, because there are several possibilities concerning these questions. And I think that some persons would be interested in cooperating for the organization of such a conference. Let's go to our friend Guillermo Pau Moreno, last but not least, who will go on. Guillermo, dear Guillermo, the floor is yours.
Thank you very much, and good afternoon, everyone. First of all, I would like to show my gratitude not only to the organizers of this event, but also very much to the, to the leader of our project, Professor Fabien Jolsosek, for organizing this panel, this parallel panel, and of course the organizations for providing us the opportunity to show what they are, some of the results that we are achieving in this project that we are conducting with the coordination of Professor Jolsosek. This is a project that is international in essence, so we are dealing with not only with European issues, but as you can see, also related to third countries. And in my case, the topic that I was choosing is the topic related to the circulation of electronic documents. Well, if you've been attending to the previous seminars, first the lecture by Professor Schuster and also the other parallel session, you will see that most of what I'm going to say has been already said or explained. But anyway, I have to say and do something. So this is the reason I'm here. Anyway, I'm not going to add or to provide much information that was already been said. Very good from both Professor Schuster and also the participants in the other parallel session. But anyway, here I am, and let's start with that. As you see, this is the title of my topic. This is the outline, very briefly, and we move to the first slide with content. Well, the idea was the following, and that is, growing cross-border mobility of persons, and that affects the personal dimension of them. And there is an increase in the utilization of civil statute records and registers. This is something that has been already mentioned. In our study, I've been dealing not only with European member state systems, but also with some systems in America, Oceania, and Asia. And from that first analysis, we've seen, and also from the perspective of Europe, also the interesting system of Switzerland, the InfoStar system. After dealing with all this system and trying to cope with the particularities of them, I mean, there is an uneven speed and scope of this kind of mechanisms has been already stressed in the presentation by Professor Schuster. I mean, there are many differences, even though there are some common issues related to the digitalization of civil statute records and documents, even though within the European Union, we see many differences, but also it's the same if you see what is happening, for example, in countries like Brazil, Argentina, New Zealand, or other, or even in China and Japan. So you can see that there are huge differences, and that affects the cross-border movement of this kind of persons, or of course the acceptance of foreign documents when they are digital, of course. Well, in that respect, what I'm trying, instead of analyzing from a comparative perspective, which are the difference, this is the first part of the project. Then I deal with the cross-border movement, and when you are dealing with that, first of all, of course, you can go to the private international systems of each country, of each not only member state, but a country which produce this kind of documents or receive this kind of documents. So I moved to the what is happening in the international level, that is the international codification in that respect. So this is the reason why my presentation touches or is based basically in what is happening in the Hague Conference, already explained, the ICCS, also explained, and the European Union. So as you can see, not offering much, but I will offer my perspective and my view. That's the personal question that I have to say. In that respect, I must stress how grateful I am for all the organizations and institutions who have answered me. Not only I have a lovely call with Nicole and Brody some weeks ago, but of course the assistant of Nicolas North, and also from the European Union. I'm expecting some feedback because they have been also very helpful to me in order to provide me of the information, and as well as some information from member states that I have received already. And of course, one of them is my country that is in the process also of digitizing, Spain. By the way, I'm the only one Spaniard in the Congress. I'm very grateful for that. Thank you for adopting me. And so let's move now to the second. I will go very, very fast because, I mean, you already know what is the apostille convention, what is an electronic apostille. So there is nothing new about this that I can add. well, you know, the importance of course, the Hague Convention of 1961, of course, the creation of the e-apostille Commission in 2003, all the meetings that they have, that there are 46 members, contracting parties working on that with different levels, with different, of course, approaches, but anyway, working in this project and offering solutions, meeting and so on. And of course, which are the elements of that? The e-apostille at itself, and of course, the e-register. Well, you have the definitions here in the slides, and you know, and the obligations of the contracting parties that is to submit some information in order to make all the system working in a proper way, let's say. Well, my assessment, that is the personal view of the system, because the system's already been commented in the parallel session, is a positive one, but I think that it has some room for improvement. First of all, because I mean, in itself is very positive, because we have this enabling the so successful apostille convention to be applicable for e-documents, for electronic documents, and the large number of contracting parties, 46, is at a great success. But anyway, you know, there is still some room for improvement in the way of how countries submit their information, how countries cooperate in that respect. And I know that from the Hague Conference, they're doing a fantastic work in order to improve, to spread, and to inform about the possibilities of working in a single and in a bilateral way with contracting parties and national authorities. So in that respect, we have to congratulate the Hague Conference for that they're doing. Now we're moving to the CIEC system. I would say in Spain, we say CIEC. I know that it's ICCS or AAC, but we say CIEC in Spain. So I will say CIEC just to make it shorter. We are not that fan for you know, all the acronyms that you use in several languages that you're also using. We try not to use it that often, because sometimes you lose the message. But anyway, it's something that happens in my country. I know the CSO4, the CIEC is doing a remarkable work. You know, all the recommendations and conventions that have provided in this respect. And first of all, I'm mentioning some of them. Of course, the analysis is in the paper and well, a short analysis because the paper is one, but I mean the white book that we are producing. Several recommendations, like number 8, the Convention 30, seminal convention in that respect. And of course, the platform that is a fantastic tool, but not working. It's happening the same with other conventions that maybe this have 6 signatories. I mean, not that few, not that much. So that means that all the seminal effort done by the CIEC, not only in terms of methodology, but also in terms of the effort produced by the organization itself, is not that so used, that unfortunately, because the effort has been great and the achievements have been also been great, and the platform itself is a fantastic tool that that could provide for a lot of benefits if in case it's going to be used. I think that we should make use of this fantastic tool, and the European Union should take in account the production of that electronic and digital tool for electronic documents, affecting also, of course, civil statutes records. Well, of course, the assessment, as you can see, is this following slide, is, of course, the CIEC is a seminal and intensive effort in that respect. So we have to congratulate also the effort done by the CIEC. But again, we see this poor level of ratification. Of course, it is difficult to assess why, but I mean, the comments that I heard from some organizations are not that in favor of that. And I will strengthen the importance of, you know, being more active and taking advantage of all these fantastic activities done by the CIEC itself. We will have the chance also in September to make an assessment of these achievements, and in order to, let's say, encourage countries in order to participate in conventions and in the platform itself. We hope that it can work in the future. Well, let's go to the European Union. What else? I mean, Alexander Schuster has been explained this morning. Not only I mean, yesterday we is being commented instead of the presentations. This is the good and already has been said everything, and to add is difficult. But anyway, it's good to remember, to remind all these different fantastic lectures we've been attending to, and mentioning all the problems, not only for the scope, territorial, objective material scope of application, also about what is the meaning of a public document and the characteristics of them. So, I mean, we all know already about the legal basis, the regulation itself. The aim of the regulation has already been explained, so you can read it here. But anyway, you've heard in previous lectures. And in that respect, let's go to the main elements. You know about them: the scope, the authenticity of the existing, the stringing dimension of documents, the cooperation system using the IME, the IMI, as we will say in Spain, the coexistence with other legislations. So this is some of the main elements of that. But if we go to the question of digitalization, then, okay, Alexander Schustes has explained it very well. I mean, there is a lot of awareness, but anyway, at the end of the day, we find not only a couple of recitals, but some provisions, only some of them, that mentions that. I mean, remember recital 9, 44, but also articles 12, 14, 4, 23, or maybe 18, and of course the revision article 26. But I mean, at the end of the day, it's 5, 6 provisions that deal with the digitalization, leaving a lot of room for countries if they want to, whether they want, and in the way that they can do it, provoking many problems. And maybe this is one of the reasons, because of the different level of speed and scope of the digital documents from one member state to the other, that creates that, that member states are so reluctant, maybe they are afraid of speeding the process of digitalization internally, and also of accepting electronic documents from abroad. Well, remember the main provisions. First, the electronic version of the multilingual standards, that's Article 12, already mentioned. The central authorities communication through the IMI system, that is Article 14, paragraph 4. The exchange of best practices, remember, already mentioned, Article 23. And of course, the application of other provisions affecting electronic signatures and so on and so forth, Article 18, paragraph 2, and of course, mention Article 26 for the revision, and they tackle especially the question of digitalization of documents. Well, this is going to be difficult. I completely agree with Alexander Schustes. That's the future. And the countries and member states must be aware of that, and they must implement. Maybe the moment the pandemic offered a very good opportunity, because many of the member states are starting to make digital their administrative procedures. I mean, that's happening in many member states. And maybe it was a good opportunity for all of us to start working more in the digital world, not in the metaverse. I mean the digital world with the digital documents. So I think it was a good moment, and many member states took opportunity to this process, this crisis, in order to make some movements. But there is still a lot of room for improvement in many of the member states. For example, just to mention one example, the Spanish example, we have already changed the civil status law and the regulations. Have entered into functioning from the last year. All the new changes. It changes from a system of books to a system of personal pages for personal persons, for persons, instead of books, that is birth, marriage, and so on. So it's changing all the system. And also we are starting with the digitalization, both in Madrid and in Barcelona. So, I mean, the two major cities of the country, and maybe and they are moving, because, I mean, I've been in contact with the ministry, and they're moving to other cities, but it's going to take a lot of time, because of the difference of the civil status registry from one country to one city to the other. Some of them, they are linked to courts, others are linked to city halls. So that makes a lot of difference of the preparation of the civil servants. So some of them, they work locally, and others work in the national level. So that means a lot of training and a lot of changes from and adapting to the new technology. Technology has been already addressed about the differences between one technology to the other, and there is not a compulsory one from the European Union. So we'll see. And that's one of the problems that member states think more locally, that is domestic, and think what is the technology I want for my country. And in some moments, they don't talk to each other. So there will be some problems of the, as I told you, the uneven speed in the digitalization process. Well, the assessment, as has been already criticized by the regulation, it has a subsidiary character to the instruments, and let's say it can be said that it's not a finished system because there are many things open to the member states and also for the possible application of conventions and other international instruments. So in terms of digitalization, we'll hope that with this review of the review clause, Article 26, there will be more improvement and there will be more, let's say, brave in tackling the question of digitalization. So okay, final remarks. Thank you. Well, there is most of the ideas that have already been mentioned during this short presentation. First, the increase of the internationalization and digitalization and the difference between one country to the other, not only within the European Union, as I told you, but if you see it locally, there is a pressure in some of the countries to do that. And there is a lot of concern, but they do it with different efforts. The system remains very complex because even for us, European member states, we have the regulation, but at the same time, you can apply to the e-apostille. And in the future, if we have the platform functioning, then we can also use the CX platform. So that means that at the end of the day, you can use different methods. In fact, through the digitalization system in Madrid and Barcelona, they are accepting public documents coming from member states, and some with apostille, called electronic apostille, others without. So that means at the end of the day, you can choose between several systems, and this makes it complex, but at the end, but also you have different tools. You can make use of them if you know them, of course, if you're aware of them, but makes the system that is complex from a legal perspective. And of course, as already been said, we have to reconsider the model. I mean, from the electronic public documents, I mean, not the system at itself. What I mean is, I've seen in some cases not a lack of contact, but I mean, not that much cooperation between different international organizations. I mean, especially the European Union with the CIEC or the Hague Conference. That means that there is a deep dialogue, of course, but I mean, there should be they should try to cooperate more, I think, especially when the European Union, all of the European Union member states are members of the Hague Conference, and many of us are also members of CIEC. So there should be strengthened our cooperation, because at the end of the day, all the organizations are interested in this process. So, and we should take advantage of the strengths that each organization has in order to reinforce the cooperation and to, at the end of the day, produce beneficial instruments for the citizens that that's the idea that we want, not only for members of the European Union, but also from third countries. So that's it. That was the main ideas I wanted to express. I'm sure that maybe none of them is new to you, because the previous lectures. But anyway, I wanted just to thank the organization itself and also the coordinator of our project for enabling me the possibility to be here in Bologna. And thank you very much. You've been so friendly here in Bologna that is going to be sad to come back to our countries, in case we can do it, of course. Thank you.
Thank you very much, Guillermo. It's really easy to chair such a panel because we still have 10 minutes then for questions. First, I fully agree with you concerning the need of a real cooperation again. And I just remind that the ICCS platform works very well. It's efficient. It's at the complete disposal of the states, of the EU also. And just remember that it has been partly financed also by the European Union. So it would be great to use such a tool because it might bring a lot of answers to some questions that you've raised. And which have been raised already yesterday and this morning. Questions, comments, maybe? Anyone? Yeah.
Thank you, Nicholas. Not a question, but a single remark. I think we are talking about e-documents, digitalization, automation, but we must still remember, for example, in France, I was talking for 2 weeks ago to my colleague central authorities. There are about 35,000 municipalities in France. And he says to me, at the best, there are 4,000 of them that can cope with the EU regulation on the level of automation. So I fully agree with everyone here, but I should say, don't let me forget the typewriter.
Yeah.
We must always be, some municipalities, even because in Holland, we think we are a guide country. Even in Holland, we are at some levels not so far. So I think we must look ahead, but sometimes it's also difficult when you're on a lighthouse to look down.
Yeah.
Please let not forget that.
Yeah, that's true, I think, but I cannot talk about France. Sorry.
No, if I can add something to what Chris said, because I absolutely agree with you. But it's not only because we don't have to forget, of course, the origin and the very beginning of everything, but not only for the authorities in itself, but also for the citizens, because the level of literacy in terms of digitalization is not the same for the different ages. So, for example, in Spain, we have a serious problem we have with the electronic banking, for example. There are some older people that are not used to use all the applications for the banks. And there has been a huge movement for people who are more, people who are 70s and so on, that, our population is old in many of our countries, and because the life expectancy, and they cannot manage all with practicalities with banks sometimes. So it's the same with this kind of electronic administration and electronic documents. So we have to go step by step. This is the reason why I understand why some member states are not reluctant, but saying, well, let's take some time and do it we combine both types of documents, but of course, that's the future. But anyway, not forgetting the origin. Thank you. I completely agree with you.
Other questions, comments? We still have 6 minutes, I think.
Thank you. I guess, and I'm not sure which of the panelists, perhaps everyone might have an opinion on it, but I guess I'm just wondering, obviously, hearing a lot about the potential or the encouragement for the call to cooperation between, for example, the HCCH, the ICCS, the EU, all those things. And I think that is happening to some extent. I know, Nicolas, you were present at our meeting last year, and I know that we kind of go to EU meetings and it kind of circles around, but I feel like we're maybe not quite getting there in terms of what actually needs to happen and how. And I guess I'd just be interested if the speakers have, particular thoughts on how to make that cooperation more concrete. And I know, particularly Fabienne, you mentioned a few ideas in terms of subject matter of things to address, but would it be something like, are we imagining a joint project, or do we need, say, the EU to take the lead and then we come in as observers? Or it's sort of, I feel like at the moment it's a bit hard to get a sense of where to go and how to make that next step more concrete in the cooperation. So I'd be interested in the panelists' views on that, maybe.
I think, Nicolas, you are the man of the situation to answer, because you're how many years are you the secretariat of the ICC, ICCS?
Not so long ago, but yeah, it's difficult for me to answer. I'm not neutral, I think, but you are not also. I think it would be great to have your external opinions. What would be efficient? I don't know if you agree, Brody, but I think it's really useful.
Marion has some idea.
Thank you. Thank you. I think there is a very key element regarding ICCS status since now the ICCS changed is a regulation, and the European Union could be a member of the ICCS. So this could be a first very important step, since the EU is already a member of the Hague Conference. So I think this is already one point. It's institutional response. And I understand that you were asking also for very concrete and practical discussion. But if we have the institutional structure, the EU member of ICCS and EU member of the Hague Conference, it would be a great step forward. Thank you.
Regarding private international law, the EU regulations are built on the convention from the Hague. Then why cannot we do the same thing for civil statutes?
And of course, and I fully agree with all that has been said, and I agree with the institutional point of view as a starting point, because I'm thinking about all the difficulties, for example, for the EU to become member of the European Convention on Human Fundamental Rights, for example, and all the road that has taken to the EU to become a member of the Hague Conference, for instance. So I think that there are institutional and borders deriving also from the structure of the organization. So maybe if each organization starts to become more open also with regards to this institutional structure and rules, maybe that could be a good starting point in order to cooperate. Because if it's difficult to become a member or also to dialogue, if you don't have the instruments, it will become really difficult to start new projects. So thank you.
Other suggestions?
I think we can see the great evolution of the Hague Conference, the implementation of the uniform private international law rules since the EU is a member. I don't want to say that the EU is the input of the Hague Conference. That's not my point. But it's true that with 27 member states, it's of course a new dynamic also to develop a uniform text at the global level. And I think that the European Union is more and more keen to develop these external relationships, taking into account the needs of third states. And that's exactly the point of the conference and of the ICCS, which are global institutions. And the EU wants also to be part of that global dialogue. So I think, okay, it was just to give concrete example of the very, very important development of the Hague Conventions since the EU is a member.
Thank you. Thank you very much. I think it's time, but time for lunch, and maybe we can have some. Still session. Okay, but during the lunch, I think that we will have to discuss, of course, together. Thanks a lot. Thanks a lot for your kind attention, and thanks to all the speakers.
I think that we could begin now. We are a little late, I think. So we will have now the opportunity to look into the policy recommendations that could be done to improve the regulation. I think it's a very important topic, but we are a little late, so I will only briefly introduce the two speakers. The first one is Lina Papadopoulou from the University of Thessaloniki, where she is associate professor of constitutional law. And the second one will be Daphne Lima, which is now doing a PhD in family law at Cambridge, and will be assistant professor in Durham next year, and which also was member of the Greek team. So, yes.
Good afternoon, everybody. We were supposed to draft the policy recommendations. Well, policy recommendations, that means we should say what we should change in the regulation. This is something actually that the regulation itself promises, because we should have had an evaluation by the Commission and next one later in 24. So the question is where we would like to head to. But as we all know already since the dialogue between Alice in Wonderland with Rabbit, the only correct reply to this question, where would we like to go to, no, which is the right direction, is dependent on the question where we would like to go to. So there's no right reply to the question which is the direction we should take if we don't know where we would like to go. And it's not on us to decide where we would like to go, it's on the member states, which were a little bit hesitant when they wrote this regulation, I suppose. And this is due to many different opinions or many different interests between the governments or the nation states. So this is something we can attest even today when we see the position of many governments towards this war of aggression by Russia against Ukraine. And we can see it also when it comes to the recognition of family or other relationships. So on us as academics, it's rather a test, because we have to make choices which are choices that are rather political. And the main two choices that one has to do, I mean, the main direction one has to choose, is whether one opts for more integration, for an ever closer union on the one hand, and on more social acceptance of new situations, new forms of families, new forms of parenthood, like the ones we have just discussed in the other room, etc. So we have done rather a paper work, let's say. We are both grateful also to Alexander Schuster, the father of the project, as he was called yesterday. And we have discussed some recommendations based on these basic assumptions, that the direction we want to go, the goal we want to achieve, is rather more EU integration and is rather more social and facilitation of the European citizens to move freely within the European Union. So this is not necessarily what the member states will want when they will be asked to revise the regulation, unfortunately, if you ask us. But that's all we can do, as we are not the legislators. So for me, that was the introduction, and Daphne will now present the specific policy recommendations.
Thank you very much to Lina for the wonderful introduction. I will try and be brief as we are running a little late. So First of all, I would like to clarify that this will be policy recommendations of the whole document cross-borders identities of the on the MOVE project. So at this conference, we are presenting some initial findings, and we're very much looking forward to feedback or any ideas any of the other partners or the audience might have. And just as Lina did, I would also like to extend my gratitude to Alexander for significantly contributing to some of the recommendations. So I will present very briefly, as I said, 7 points that we think might be up for discussion as recommendations on where the regulation and its application might go. The first one is the expansion of the scope of the regulation. The second, which is connected to the first, is third country documents that are incorporated into member state public documents. Excuse me. The third and the fourth, which are more policy oriented, are encouraging harmonization and matters of recognition and raising awareness of the regulation among public authorities. Fifth is translation aids. The sixth is on digital documents, where our expert, Alexander Suster, significantly again contributed. And the last point is direct exchange of data. So with regard to the first one, the scope, the expansion, the potential expansion of the scope of the regulation, as you must have heard quite a few times already during this conference, the regulation covers specific facts, public documents that attest specific facts such as birth, death, a person being alive, marriage, civil partnership and dissolution, parenthood, adoption, nationality, and so on and so forth. So these documents, these facts that are covered by the regulation are connected more to EU citizens and their personal status as they move along, as they exercise their freedom of movement. And one of the main points that we wanted to raise is that the scope of the regulation should also be expanded to the EU citizen as an economic citizen, because that is very integrally connected to the exercise of the freedom of movement. So as was envisioned in earlier drafts of the regulation, its scope should be reviewed to potentially include documents that are connected to educational, vocational, and work qualifications and experience, but also to other aspects of someone's economic life that might be important to be able to duly and easily attest when you move across borders, such as property or real estate documents, public documents again, or documents related to tax, health insurance, disability, and certain facts that are connected to benefits. And that is, this expansion is far from a utopian project because, as Lina already flagged for us, this is envisioned in the regulation itself. Under Article 26, there is this process for review of the scope of the regulation, and more specifically, there is a specific process where the Commission should have submitted an evaluation report by February 2021. This is still pending, as far as I know, with regard to extending the scope of the regulation to include specific facts, namely public documents relating to the legal status and representation of a company or other undertaking, diplomas, certificates, and other evidence of formal qualifications, and public documents attesting an officially recognized disability. We would also like to flag that this expansion should be reviewed alongside other EU initiatives regulating specific issues to ensure that there is no overlap, or to draw on best practices such as the European Certificate of Succession, or perhaps the recent work on the EU group of experts on a potential European Certificate on Parenthood. It still remains to be seen whether that will go ahead. And that is connected to the second point that we would like to flag, that is that the regulation should also review or clarify the provisions of public third country, but already incorporated into the public registries of the member states. And it should also explicitly provide for circulation of documents on marriages celebrated by a religious minister that is not vested with the authority of a public official of a member state, but is fully recognized by the latter. For example, a marriage celebrated under the Concordat between a member state and the Holy See. And as it was said earlier in one of the early sessions today, maybe this scope of the regulation was a test run for more facts to be included in the future. So we think that especially this initial few points are very easy to discuss and to open a discussion about them. The third and fourth points are a bit more, we should be a bit more discreet because they're a bit more sensitive. They touch upon the sensitive issue of recognizing effects, which we know that the regulation is about facilitation of circulation of documents and not recognizing the legal effects. So under recital 7 of the regulation, it is explicitly said that this regulation should not oblige member states to issue public documents that do not exist under the national law. And this is very much in line with the theme of the regulation, that we are not recognizing legal effects to the public documents, and we're not requesting a full harmonization. However, even though this will not drastically change, in order for the regulation to be able to produce its full force in practice, member states should be encouraged to recognize some effects, or to have instances where the member states should be encouraged to sort of harmonize the type of documents that they use to prove certain facts. At this point, there are instances where member states use significantly different documents to prove the facts included under Article 2 of the regulation, or indeed have no public documents to do so. The public in of itself for attesting that the person is alive. So while member states cannot be obliged, of course, to issue certain, would immensely facilitate freedom of movement if they were encouraged to at least provide for documents that can duly attest all the facts included under Article 2 of the regulation. And in the same vein, member states should be encouraged to provide as much detail as possible on the e-justice portal with regard to public documents, where national information on online forms are stored, because currently there are, again, wild discrepancies on the amount and detail of information included on the portal. However, this can only function, again, at the level of encouragement. And whether any matter that touches upon effects and legal validity is better left for specific initiatives, such as the European Certificate of Succession. Finally, on this point, member states should also be better assisted in selecting the country-specific headings they deem relevant to communicate to the Commission and to be mentioned in multilingual standard forms, because the headings so far seem to be far too many and may lead to confusion. And this brings me to my fifth point, raising awareness among across public authorities, but also the general public. And this is a conclusion that could also be drawn, I think, from the trainings that this project has organized, at least in the trainings that our team organized, which were, of course, targeted to a very specialized audience, right? Legal professionals who already had an interest in the regulation. And even among that very specialized group, awareness of the regulation and its effects and its scope of application was quite low. So if this is transferred to the general public, we can expect an even lower threshold. So this has a domino effect of a lower chance of potential application of the regulation or of professionals who applied being able to recognize the complications and issues that arise in practice. So a threefold information campaign targeting public authorities implementing the regulation, legal professionals that would be the first line of practitioners most likely to seek the application of the regulation, and the general public that might benefit from it, would be crucial in order to ensure the frequent application of the regulation and thus also a more thorough assessment of its impact. And last but not least, the final 3 points. One is the translation aids. One important aspect of the regulation is the introduction of the multilingual standard forms and the simplification with regard to translation and circulation of public documents drafted in different languages. And in this context, we submit that the regulation should extend the number of multilingual standard forms to the greatest number possible of situations. Multilingual standard forms are useful also when they are such as private employers. So their usefulness should not be limited, whereas the field of application of the regulation mentions circulating only among public authorities. It shouldn't limit the right to obtain them and use them in front of private entities. However, the regulation should specifically mention or a dissemination on how multilingual standard forms may also simplify the circulation of public documents among private entities. For instance, the marriage form and an ideally upcoming filiation form could be of great benefit to any employer seeking proof of existence of family members in order to grant company employers. With regard to digital documents, the regulation should explicitly tackle and regulate electronic public documents and their circulation. And this could ideally take place in view of the ongoing revision of the eIDAS regulation, as Alexander has also gone into great detail this morning. There is a great array of different solutions and regulation among member states applying to public documents in digital format, and there is need for some common ground. So eIDAS compliant public documents in the form of a qualified electronic signature or seal should not be rejected due to merely being in digital format. The repository should also have a section on digital documents, and the e-justice portal should also expand to have a specific section on verification methods of electronic public documents issued by every member state, which are often not eIDAS compliant, but qualify as public documents according to domestic law. And the role and relevance of XML schemas as applied to public documents developed under the ISA 2 program should be explicitly mentioned in the regulation, and their application should be put to good use. The new Interoperable Europe program should further invest in these schemes. And one final point on this, in line with this, the regulation should also explicitly acknowledge the circulation of public documents as data sets or digital records, i.e. data ideally in the format of an official XML scheme without any paper layout as customary in PDF documents, for example. A revised regulation should also apply, establish clear links to the single digital gateway instrument and harmonize the approach to public documents that are covered by both regulations. And without one final point that is, I think, the most open to discussion, it should maybe be discussed whether the regulation could experiment with new ways of allowing direct exchange of information and or documents between member states authorities, such as especially documents required to vote or stand as candidate in elections for the European Parliament. So that was very briefly potential policy recommendations from us, and we're very much looking forward to your feedback or to lunch. Thank you.
Thank you both for your very interesting and very brief presentation. I think that it could arise lots of questions. And if somebody has a question. There is no question. Oh. Yes, we can discuss this. Discuss it over lunch if you want.
Send us email if anybody has any good ideas
And recommendations. We would be happy to receive your feedback even later after the conference, of course. Thank you.
Okay, thank you then.
Bonjour. Merci beaucoup. I think I need to switch to English, right?
Yes. No, in English. It's okay in English. It's only my French.
Okay. Thanks a lot. I would like to start with thanking the organizers for inviting me. I think that you will believe me if I say that I would rather be in Italy than in rainy Brussels today. But unfortunately, I was not able to join the conference, to be with you in person, because I had another meeting of the European Judicial Network at the exact same time. So this is why I could not even attend the conference online. I'd be very happy to know about the findings of the conference. And I must say that I feel like I'm taking the floor blindfolded, because I don't know exactly what you have discussed. I don't know exactly what the outcome of the discussions have been. And it may be that I will repeat some of the findings of the conference. Then I ask you to apologize me, of course, if I'm repeating whatever you have said, or maybe I will raise some issues that, I will reach conclusions that you haven't reached yourself. So I will indeed present you the regulation from the Commission's perspective. I must say that it's not as easy as it seems, since the Commission is most of the time in the thick of things, and we don't usually have time to take a step back and to look at the regulation from a distance. So we're only following up on the issues that are signaled to us by the member states, by the public authorities, by the citizens. And I think it's a good opportunity today to take a step back and to look at what has been done during the last 3 years. I'm very proud to say that I was I have been working on this regulation almost from the very beginning, because I actually joined the French Ministry of Justice and was responsible for the implementation of the regulation in April 2017. I participated to the preparation from the French side, and then I joined the Commission in January 2020 and was lucky enough to also be appointed as in charge of this regulation. I had a PowerPoint presentation, but I don't know if it has been transmitted to you, or if I should just, I mean, it's not necessary to have the PowerPoint presentation. It's just to structure my presentation for the people listening. But if it's not available, then
yes, so just a minute.
I must say I sent it very late yesterday. Yes. Or maybe I can share my screen. Oh, okay. Thank you. So if you can go to the next slide.
Okay.
Thank you. So this is the main points that I'm going to present today. It's not very surprising that I will start with the successes, then of course also cover the remaining challenges in the implementation of this regulation, and I'll say a few words about what I think are the next steps. If you can go to the next slide, and then again. When I started the assessment of the regulation for the purpose of this presentation, straight away I started thinking about the issues that have been raised, but I thought that it's not fair to focus on the problems first, and I really wanted to mention that this regulation first of all, is a success, and that it's being implemented every day. And even though there are challenges, we can say that in 2022, the implementation is now smooth, and that we have we have seen that some achievements of the regulation are great. The first item that is that I believe is a success is the committee that was created by Article 23 of the regulation. This committee has been meeting a lot since 2017. The first meeting was on 12 May 2017, and since then we had 13 meetings of the committee. This committee has been established to share good practices and to discuss possible issues, and to take any measure that will be necessary, that has been necessary and will be necessary in the future to make sure that the regulation is correctly implemented. This is not always the case that a European regulation establishes a committee to make sure that this instrument is correctly implemented. In the field of civil justice, for instance, we don't have such committees. And the only way member states can meet and discuss the implementation of the other instruments that I'm talking about is the European Judicial Network. But this network is only meeting 6 times a year, and we have more than 20 regulations. So as you see, it's not possible to review the operation of each regulation frequently. And it's, of course, we try to do so, but it's not possible to meet as often as we would want, and as often as the member states would want. For the public documents regulation, on the contrary, the committee has no specific rules on how often it should meet. And so at the very beginning, it would meet very often. In 2017, I think we had 3 meetings. 2018, we had 4 meetings, and we were actually busy with the preparation of the entry into application of the regulation. The regulation is applicable since February 2019, but before that, a lot of work was required from the Commission and from the member states to have the multilingual standard form established and uploaded on the e-justice portal, including all the country-specific headings for each member state. So I'll come back to that later on, but this was a great deal of work for the committee, for the member states, and for the Commission. Now that you can still go back to the previous slide, where I'm still talking about the committee. So now that the regulation is actually being implemented, so since February 2019, the committee has reached a cruising speed, I would say, and is meeting at a more steady pace. So we are not meeting 4 times a year anymore. And of course, during COVID, we couldn't meet at all. But we used to meet twice a year for the last few years, and we just decided, because we had a meeting at the beginning of June, we just decided that we would meet only once a year as of 2023, unless, of course, there is a particular issue. And this is, I would not say that the COVID pandemic was a blessing in disguise, but this was one of the hidden benefits of the pandemic, was that now we have more flexibility to meet online. And this is also something possible for the committee to discuss one specific issues that would arise. We could have a short online meeting. We don't have to meet in Brussels. So how do we work in the committee? There are, as you know, the regulation is touching upon multiple aspects of the circulation of public documents, legalization, apostille, translation, certified copies, and then all the verification through the IMI platform. So we usually start with information points from the Commission. And then we have a tour de table where all the committee members share their the latest development in their state and possibly ask some questions and explain about us had before we met. Some examples of what the committee has done in the past. All the minutes of the committee are public on the expert group repository of the European Commission, so it's accessible for everyone, and you can always check what we've been doing and what we what we're going to do in the future, but just one or two examples. We adopted a common text to inform citizens on the consequences of this regulation for citizens. So we discussed it. I think it took us 3 meetings to agree on the common text, and this text can now be made available by all member states. This was to avoid that we would inform citizens in a different way in the EU. We also, because we were receiving quite a lot of complaints, especially at the very beginning of the implementation of the regulation, and I also come back to that later on, we decided that we would have a list of contact points to which we could refer citizens who are writing to us, and sometimes the Commission is not in a position to reply because this is a very specific issue that a citizen has in a specific case. So we decided that we would first advise those citizens to reach out to their own competent authorities. So we have now at the Commission this list of contact points, and whenever someone writes to us, we can refer them to their national authority, hoping that they will help solve their problem. And the type of questions, legal questions that we have been discussing in the committee is, for instance, whether it's possible to attach a multilingual standard form to a certified copy. This was raised by one member state. There is no clear answer in the regulation. The Commission, of course, has always advocated that it should be possible based on recital 8, I believe, and the intention of the legislator to attach a multilingual standard form to a certified copy. But we have had quite a lot of discussions, and then we decided, because we couldn't reach a consensus on that, we decided to wait until the question is asked again, because in practice, apparently, it doesn't really happen that this question arises. So we've been discussing that point, and we may still discuss it in the future. You can go to the next slide. So the second achievement, I must say, of this regulation is the functioning of the IMI module that has been built for the public documents regulation. So as you know, IMI is a platform developed and maintained by the Commission. It is used for many other regulations, and its objective is to allow public authorities to exchange with each other, to communicate with each other. It is used for very different regulations, such as the professional qualification of the use of firearms, etc. It is also used by the European Judicial Network, by the way. One specific thing is that the functioning of IMI for the purposes of this regulation is really excellent, I must say. We haven't really received any complaints from the users. Member states are happy with the functionalities provided by the system. And of course, at the very beginning, there were questions. We had some issues, and it took some time for some member states to register and then to know how to use the platform. But it's quite user-friendly. The functionalities are very simple. Unfortunately, I cannot show you how it works, but it's very easy to use. And mostly member states are happy with the system. We can see that it's being used from the very beginning by the central authorities and the public authorities. And still now, we have requests for verification every month that are sent to different member states. In the repository of the IMI platform, where member states can upload models of public documents, we have a high number of models, even though we are always asking member states to upload as many models as possible so that public authorities can check whether the public document they have in front of them is similar to the one in the repository. We are quite happy with the number of models we have, and the response time to the requests for verification was not satisfactory at the beginning, but it's getting better. And this year, actually, member states are on average replying to the request within the time prescribed by the regulation. In 2021, it took on average 20 days to reply to a request for verification of a public document. And during the first 5 months of 2022, the average response time was 9 days. So this is within the 10 days provided for in the regulation, and we're happy with that. If you can go to the next slide. The third point that I wanted to cover in the list of successes of this regulation is the work that has been done on the European e-Justice portal. So I hope that you all know the page on the e-Justice portal that is dedicated to the public documents regulation. We have there a chapeau page, as we call it, where you will find all the general information on this regulation and what it does for citizens and how it works for public authorities. There is a link to go to the notifications that were made by the member states according to the regulation, and there you will find all the practical information that are necessary when exchanging public documents or sending out requests for verification. There is also a link to the repository of public documents. So you don't need to actually log in IMI. You can already access this repository from the e-Justice portal. It's accessible for all public authorities. There is the list of central authorities to clarify in each member state which institution does what. And then we have the multilingual standard forms. I put dynamic in brackets because at the moment it's only fillable PDF, but we hope that before the end of this year, we will have dynamic forms, meaning that all public authorities will be able to complete those multilingual standard forms on the e-Justice portal with the flexibility and the assistance that is provided by the dynamic format. So it's going to be much easier for them. And I must say that I have checked the number of visits of the public documents page on the e-Justice portal, and I'm very pleased to announce that this page is actually a winner because it's the first. It was the first page visited in 2021. So there is a lot of information on the e-Justice portal on a multitude of regulations, instruments, fundamental rights, civil justice, criminal justice, and still this page is apparently the most successful. I have, there were in 2021, there were more than 120,000 visits. So it's the most visited page on the portal. About the multilingual standard form, I should also say that it was a lot of work for the member states to come up with country-specific headings that we could accept and include in the forms. It was also a lot of work from the Commission side to have this developed. And still nowadays, each time a member state changes something in its law and changes something in its public documents, we need to update those country-specific headings. And we need to translate every change we make in all EU languages. So it's kind of a challenge, but we're doing it as soon as we can, and usually within 15 days, the new version is uploaded on the Justice portal. So it's the cooperation with member states is well functioning as well. And I will now, turn to the challenges that that remain when implementing this regulation. If you can go to the next slide. So one point that has been raised from the very beginning and is still what I should call an issue in the implementation of this regulation is the circulation of electronic public documents. I'm quite sure that you have discussed that point already, so I won't take too much time on that, but I wanted to clarify that although the public documents regulation is quite clear on the fact that it covers electronic public documents, in the real world and from the complaints we receive, it is not as easy as it seems. We have had quite a lot of complaints from citizens who had an electronic public document that was not accepted in another member state. It could be that it was just because the other member state was not really aware of the requirements and wanted to make sure that the paper version was provided, so there was no doubt on the acceptance of this electronic public document. It could also be that some member states have requirements that don't allow the submission of electronic public documents. Our interpretation is that in principle, looking at the eIDAS regulation and the public documents regulation, in principle, electronic public documents should be accepted by all member states unless there is a specific requirement in the legislation of those member states for a specific format. So it could be that only paper is accepted. It could also be that, for instance, only qualified signatures are accepted. This is very possible. So we did not only receive complaints from the citizens, but also we received queries from the public authorities to be informed on the requirements, the conditions for member states to accept those electronic public documents. And we decided to start working on that. It's typically the type of measure that the committee is entitled to take to ensure smooth implementation of the regulation. Unfortunately, we haven't reached a consensus yet. Due to some local national constraints, all member states are not ready to share information on the conditions to issue and accept electronic public documents. So it will still take a little bit of time, but I'm very optimistic that in 2023, we may be in a position to publish reliable information on the Justice portal to inform the citizens and the public authorities on that point. I mean, it's only, of course, it's my personal opinion on that, is that I feel that also because of the COVID crisis and the surge in the use of electronic means in general, some member states feel a little bit ashamed that they sometimes still require paper documents, and they are not completely clear on their own requirements. And that's why they want to postpone the discussion to make sure that the information provided is up to date and is complete. And also that they don't appear as the ones rejecting electronic public documents. I think that's it for this topic. So if you could go to the next slide, please. One other challenge that has been there from the very beginning and that we see is still there is the lack of information of citizens and the lack of information of public authorities who are responsible for the implementation of this regulation. So I refer to the e-justice portal as a success, and it is indeed a success. But we should also be aware that, first of all, it's the e-justice portal. So it's a specific portal used by the Commission as a one-stop shop to inform about the justice systems. And it is not as well known by the civil registers, for instance, as it is known by the courts or the lawyers or the notaries. So maybe it's also one of the reasons why, even though the page is the most visited, some competent authorities are not aware of the existence of this this information that is readily available to them. In addition, unfortunately, some member states have not launched a campaign to inform their citizens and their competent authorities. And when we did a survey in 2020, most member states informed us that they had, in a way or another, informed their population and their competent authorities about the regulation, but a few ones had not done anything yet. And I just learned, actually, beginning of July, I will not name and shame the member state in question, but one member state has been promising from the very beginning to have general information of the competent authorities, including the civil registers, and still has not done this information, and is still planning on launching this information campaign. And it is not the smallest member state. So, and we see quite often that many competent authorities are not at all informed of the abolishment of legalization or the existence of multilingual standard form. For instance, we had a case last year where a registrar from a state that I will not name was refusing to issue a multilingual standard form. And so the citizen reached out to us. We intervened. So the registrar in question had an email from the Commission asking him to please issue this multilingual standard form and reminding him of the existence of the regulation. And the registrar replied to us that he was sorry, but until he would get an official circular from his own authorities, he would not apply the regulation. So ultimately, we reached out to the central authority, and it was settled. But it's a good example on how important it is for the competent authorities to receive information from their own ministries, and then they can start implementing the regulation. And then on IMI, so I also presented this as a success, and it is working well. No, it is working well, but we also see that even though the tool is being used every month, the number of requests is quite low. In 2021, we had 62 requests for verification, so it's a very low number. But this is not really, the number is not telling us anything until you look at which member state is sending requests for verification. And there you see that some member states are active. They have a low number of requests, but they are sending out requests. Whenever a public document, they have doubts on the authenticity of a public document. And you see that some member states have never sent a request during the last 3 years of implementation. And even for the biggest member states, you can see that some of them have never sent a request. And of course, it may be that there has not been any doubt on the authenticity of a public document in those member states, but I would say that the odds are quite law, and that it is also a sign that public authorities do not know that they are entitled to ask for the verification of a European public document if they have a doubt. So the level of awareness is not the same in the EU, unfortunately. Then you can go to the next slide, and I will reach the final part of my presentation and try to discuss with you what the next steps are for the Commission and for the Member States. I'm not going to beat around the bush. The Commission will not be in a position to comply with the deadline that was set by the regulation to make the first assessment of its operation. We have already missed the deadline anyway. It was 16 February 2021. So of course, we will make all efforts possible to comply with the deadline set by the regulation. But first of all, we have limited resources within the Commission and have to prioritize in between, as I said, the 22 regulation that we are monitoring in my unit. And second of all, we found out that because the regulation was not promoted as much as it could have been at the very beginning, because the level of awareness was not satisfactory, because we still had many issues to sort out, such as the circulation of electronic public documents. We found out that it was premature to make the assessment now, and that in a couple of years we will have the distance that we need to really properly make the evaluation of the functioning of this regulation. On top of that, there are other initiatives, and of course, this regulation is not exclusive of other initiatives. As you know, it only covers certain public documents, and only for an even more limited number of public documents we have, for instance, the multilingual standard form. So this regulation has a limited scope. And doesn't prevail over any other instrument. And so it is possible to have similar initiatives in other areas. And this is the case, for instance, of the preparatory work that is being carried out by the Commission on upgrading digital company law. So there we are still in the exploratory phase, and of course, there is no official proposal from the Commission, but among the different aspects that are being looked into, we have the public documents establishing the existence and the legal representative of a company. And they could be covered by this new initiative in terms of facilitating the formalities such as the legalization, the translation. So it's very well possible that a future initiative on company law will cover public documents in relation to companies. It's the same for the current preparatory work on the EU disability card. Again, we are still in an early phase, and I cannot, of course, promise anything, and we still need to assess the impacts of the policy options. But if an EU disability card would be adopted with, for instance, some specific security features, then maybe we will not need to cover the public documents in relation to disability in a future instrument. So those are two examples of ongoing works in the Commission. And of course, we also need to look at what will be done in the context of the single digital gateway. I believe that you have discussed that point already, and that you are aware of this regulation and the exchange of data in between, the direct exchange of data in between public authorities, where you don't actually need to have the public documents submitted by your citizens, because within the EU, public authorities will simply exchange what we call evidence, structured data in between them, electronically, of course. And also we have the EIDAS regulation that is being currently revised. And this regulation may also clarify the question of the circulation of electronic public documents and the acceptance of electronic signature. So again, I think that we still need a little bit more time before we start the proper evaluation of this regulation. And I think that, yeah, in a couple of years will be the right time. I've reached the end of my presentation. Thanks a lot for your attention. And of course, should you have any question, I'd be very happy to answer.
Thank you so much. Thank you so much for your intervention. Are there any questions from colleagues? Interventions? No question, no intervention. Thank you so much.
You're welcome.
Thank you so much. We continue with the works of the afternoon works. Cinzia Perero, please, on stage. Thank you so much. Grazie. No. Nice. Okay.
Ok. Sì, più vicino. Ma cosa siamo in conference room? Join. Sei già connesso? Just English. E c'è anche, c'è anche tedesco italiano?
Tu adesso parli tu, non ti può fare.
I'm gonna speak in English. Okay, here we are starting the last session. First of all, I'm really thankful to Professor Laura Calafà and Alexander Schuster and all the project team and all the participants. They told me to be quickly and just to inform you that Irena is going to speak in German. For all of you is gonna be, would you like to follow? Irena Ryzankova, right? Studied law at the Mazarykova University in Brno, Czech Republic, and obtained with honors an LLM degree from the University of Göttingen, Germany. She's currently a doctoral student at the University of Göttingen, and her research focuses on circulation of public documents in European Union. From 2018 to 2020, she worked as lawyer linguistic at the Court of Justice of the European Union and completed a visitorship in the chambers of the Advocate General Michael Bobek. Should have told me before. At present, she works as a research assistant at the Institute for Notary Law of the University of Göttingen. Her presentation in German concerns the regulation in comparison to the ICCS conventions and other relevant international conventions, especially the Hague Apostille Convention, right? So you're going to explain us what does the regulation tells us about the relationship with these international instruments and conventions. So please, Irena, the floor is yours.
Thank you very much. And thank you. I will do my best, and sorry for the trouble with German. But now I will switch to it. So, yeah, sorry. So, sehr geehrte Damen und Herren, es ist mir eine Ehre, hier heute sprechen zu dürfen und mit Ihnen die Ergebnisse zu teilen, zu denen ich gekommen bin, als ich die Verordnung mit dem Apostiller Übereinkommen der Haager Konferenz, den Übereinkommen der CIEC und dem Brüsseler Übereinkommen verglichen habe. Die Verordnung sollte ursprünglich nicht als lediglich eine weitere Komponente in dem breiten Mosaik an Vorschriften, die den internationalen Urkundenverkehr regeln, darstellen. Vielmehr sollte sie durch Abschaffung der Echtheitsnachweise und Einführung von Übersetzungsformularen für den innereuropäischen Urkundenverkehr eine Vereinheitlichung bewirken und den EU-Bürgern dadurch zur effektiven Inanspruchnahme des Rechts auf Freizügigkeit verhelfen. Bei der Suche nach einer gesamteuropäischen Lösung betrachtet der Verordnungsgeber jedoch kein Neuland. Vielmehr schöpfte er seine Inspiration aus den bestehenden Instrumenten. Das erste Ziel der Verordnung steht die Abschaffung der Echtheitsnachweise dar. Deren Hauptfunktion ist es, die Herkunft der Urkunde zu belegen und den Urkundenverkehr dadurch vor Fälschungen zu schützen. Im innerstaatlichen Verkehr sind sie nicht notwendig, da dort die Echtheit
the origin of this convention and its utilization and uses the legalization. This is a chain of authentication from the consular representation for its use and should be confirmed. And this is no further effectiveness. In international delegalization is very complex and lasts long. There are two kinds of legalization. We have the simplified preventive verification of authenticity with the possibility of a subsequent check. There is no comparative instrument in the world. The legalization and apostille are not replaced, cannot be replaced. We have multilateral and international agreements. Only a part of these instruments have an autonomous mechanism of authenticity. This was replaced by a certificate. We had in the past millions of apostilles. These international instruments we want to abolish these instruments. There were lots of rules that were created. The bright utilization of this as mechanisms of protection. For this objective, we have a multilingual formula. The 18 member states of the EU are using this instrument. The abolition of the authentication. This was never it is a temporary solution for Italy, Lithuania, Latvia, Bulgaria.
Übereinkommen von den mitgliedstaatlichen Behörden ausgestellt wurden, aus dem Anwendung
a unified solution for everyone could not be fulfilled by the Commission. The applicable area in comparison to other conventions is just restricted to certain areas. The authenticity and the proof of this is also similar to the regulations in the conventions. This was done for practical reasons because the member states have been using those conventions for some time and therefore have experiences with this. The main purpose of this regulation is written in Article 4, which is the abolishment of the necessity to prove the authenticity of an official document. The legal consequences were not really determined in the regulation, but they were subject to the country law. And the abolishment of this necessity to prove the authenticity is very important. So it had to be assumed that the document coming from abroad is authentic, as it is the case with documents issued in the same country, such as in Germany. So Germany had to accept documents from abroad and treat them such as German documents. The necessity for multilingual forms was also determined because this was seen as an obstacle for the free movement of EU citizens. And as an example, the agreement number 16 of the ICCS was taken. And this also covers certificates such as marriage and death certificates. The agreement gives them a legal authority because they have the same proof powers, such as documents that are issued in their own country. When it comes to the acceptance of cross-border issued documents, it's again the regulation that is to determine this. In the legislative process, there have been some changes. In the original draft, they were seen as an own public document, which was seen as an alternative to a document that was issued by their own country. And instead of having the same power of proof, they had to accept also documents from other countries. This alternative was not accepted by the delegations. But there were no concerns about the translation assistance, so this suggestion was accepted. These forms are issued by the authorities in the member states. They issue the document, sign it, or put a seal on it, but they are not independent documents. Legal consequences are not included in its structure. The ICCS documents are almost the same as compared to forms issued by the other international conventions. There are glossaries in the EU forms, but there are differences in the effect of these documents. The translation assistance is just seen as an alternative, but should not have any legal consequence. Without a translation, they cannot be circulated. It is just a language assistance which has the function to make it possible to understand the document. When it comes to EU forms or ICCS documents, it's two different legal categories so that there are no interfaces between the regulation and the conventions. So the regulation is not replacing being in conflict with the ICC as the regulation. So the citizen can choose to either have a ICCS printout or to use a national printout according to the EU necessities. So as a conclusion, I can say that the purpose of this regulation to have a harmonization of the circulation of documents has not been achieved, but this can be improved in the coming years. And in reality, we will see if the regulation will be dominant as compared to the Apostille Convention and other international conventions. And this regulation has the the other conventions and international agreements have the advantage that they are better known as compared to the regulation, which is not very well known. Thank you for your attention.
Thank you very much, Irene. Ok, we try to switch. Vuoi spostarti per le slide? Perfetto. So thank you also for the interpreters. I'm going to ask the speakers to speak a little bit slower so they can translate properly. We missed some parts actually, but I tried to follow, and I have only one consideration that you underlined: the fact that the international conventions and the regulation actually pursue the same objectives of facilitating circulation, etc. And it helps me actually to move to the next speaker. If someone from the audience has some questions, I can collect them now. Okay, so let's move, because my question actually is, in practice, what happens? Because then we have to refer our questions, as you told before, to the implementation, the practical implementation of the regulation, so to the legal practitioners. And that's why I'm very honored actually to introduce Renzo Calvigione, that of course everybody knows, expert in demographic services, esperto a NUSCA in materia di stato civile, autore di numerose pubblicazioni,
always on the topic of civil status, and he is the director of the newspaper Servizi Demografici. He is also the author of different articles that have been published in different law newspaper. He also cooperates with institutional authorities for the digital transformation of the civil status services. To mention the last publications, Diritto Applicato Civile, and also different papers on the affiliation in Italy, according to the judgment of the European Court of Justice. So thank you, Sergio.
Circulation of documents in case of reasonable doubt as to the authenticity. So is it this IMI system that also the European Commission representative talk about actually used or not, or whether it is extensively or not used? Thank you, Renzo, please. The floor is yours.
Grazie, buon pomeriggio.
Good afternoon, everybody. After listening to the numbers on IMI, I should talk about the IMI solution to guarantee the circulation of documents. After listening to the numbers of use of IMI, I would like to skip to the next topic. So I will be really brief, and I would like to provide you a theoretical framework of the situation. As what concerns practice, the numbers are really, really low, also in Italy. So this is one of the institutions that maybe didn't get the success it maybe deserves. Maybe we can also wonder why. What is IMI? IMI is useful to verify the models of available documents to understand if, in case of reasonable doubt, what kind of doubt can be tackled. IMI is a system of the internal market information that was created back in 2012 by the European regulation. This is an online tool, a multilingual tool that enables the exchange of documents among member states. This is why it allows for verification, authentication. This is a network that connects local and regional authorities, and this is a safe tool also what concern the data protection. It includes a multilingual repository that help users to find the competent authorities. It also enables a direct exchange among authorities of different countries. The functioning should be quite easy. So, for example, if a public functioner who works for a EU member state needs to select a series of questions, he can do that and send this set of questions to the authorities of another member state. The authority of the member state that receives the questions receives them in its own mother tongue and can send an answer that will reach the applicant in his mother tongue. So it's quite an easy tool. Also, the response tools have reduced. Now the waiting time is more or less 9 days, as the 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 colleague said before. The average should be more or less of 15 days, so quite a good amount of time. How can we use IMI? Authorities, in case of reasonable doubt on the authenticity of a document or of a certified copy, the authorities of the member state who receive these documents should have the possibility to verify the models and to present through IMI requests for information to the competent authorities of the other member state. So this tool should work in an efficient way to solve potential doubts or uncertainties or fraud hypotheses that can arise from documents that move around the territory of the regulation. It's clear that Article 14 of the regulation, which is called as claim of information in case of reasonable doubt, aims at finding solutions in situation in which reasonable doubt arouse. This should be an easy tool, but in some cases, like for example in Italy, it got complicated, and maybe this is the reason why this tool is not used very much in Italy. Or maybe we are the best of the member state and we don't have any doubt and we are convinced that everything is good. We also have another hypothesis. The numbers concerning the use of the regulation are also very few, so that it's not very useful when people need to use IMI, because the regulation itself is uh, is used in very few situations. The reasonable doubt that is the focal point to be solved by MIMI concerns the public document or the certified copy, and it concerns the authenticity of the signature, the ability, the capacity of the signee of the document, the identity of the seal or of the stamp, or the tampering of the document. So we have four hypotheses that are tackled and that can represent a reasonable doubt. I would like to analyze them um, briefly, but it's clear that these hypotheses are quite rare in the practical use. So even if we had a high use of the regulation, this kind of situation shouldn't be so often. So they shouldn't represent um, a very frequent situation. What concerns the signature authenticity, this is the first hypothesis. So, for example, when the signature is not corresponding to the particulars of the public officer who released the document. Also, in this case, this is not a very frequent situation, but this hypothesis could represent a doubt and could need a situation according to IMI. The capacity of the signee of the document. In this case, we should verify the legal capacity of the signee of the document. That is to say, if the subject had the possibility, the legal possibility to sign that document. Also, in this case, it's not something that happens very frequently. Can happen, for example, that a document should be issued by a certain authority, but in the end, another authority releases the document. For example, in Italy, a document should be issued by a registered, and on the contrary, um, this document has been issued by an employee of the civil status register. So we cannot take for granted that every authority has the legal capacity to issue every kind of document. Third situation, the identity of the stamp or of the seal. This is not frequent as well, and it's quite hard to imagine such a situation. It means that the seal or the stamp do not correspond to the authority who issued the document. This is part of the situation in which we have a situation which is not clear, so we can verify the correctness of the document. However, to be honest, also from a practical point of view, these hypotheses are quite hard to take place or to be frequent. The last hypothesis concerns the tampering or the falsification of the document. In this case, we are talking about a document, a fake document that is presented to a certain authority. Of course, this is something really hard to verify. Something strange should happen. So, for example, um, the different parts of the form do not correspond to the multilingual standard form which has been attached. So we could think that certain parts of the attached form were tampered. So again, this is not frequent, but also here we could have a justification to use IMI. So this is the general framework. But also in this case, there are very few realistic situations that can happen. Moreover, in Italy, we also have disposal of the Internal Affairs Ministry that we can revise briefly to understand why IMI is not used that much, because this situation got even more complicated. The Internal Affairs Ministry issued the needed guidelines to registrants with the circular letter back in 2019. So these guidelines were based on the different hypotheses. So, for example, if a member state asks for the verification of an Italy issued by Italy, and also vice versa. So, Italy needs the verification of a document that has been um, issued by another member state. So we can tackle the two hypotheses in different way, but the process is more or less the same, and we can divide it in different steps. When we receive the claim from another member state, so when a member state uploads on the IMI platform the claim for verification of a document that was issued, for example, by an Italian municipality, this document is transferred by the Internal Affairs Ministry, so by the Italian Central Authority, to territory authorities, to the prefecture, and then the prefecture transferred this document to civil registers. So the process is quite hard, it's quite complex, because instead of reaching out directly the competent authority for the um, verification, we also have another third part, intermediary part. And the same process is true also for the response process. So once the municipality has verified the authenticity of the document goes to the prefecture and then to the internal affair ministry, and then is uploaded on the IMI system. So there are different steps to be undertaken, and this process is, as I was saying before, more complicated. What's the consequence? The opposite process is the same. So, for example, if an Italian register should verify a document that has been presented um, and has been issued by another member state, also in that case, carry out the verification, the municipality should present the claim to the prefecture. The prefecture then transfer this claim to the internal ministry, who works on the IMI platform. Once the the answer, the response is present on the IMI system, then this response is transferred with the same process to the register, so to the municipality, always undergoing the different steps that we mentioned before. That's quite a difficult process that doesn't not facilitate the use of IMI. And maybe this is also why we have such low numbers of the concerning the use of IMI. I would like to emphasize that I think that the use of this tool also beyond the hypothesis of reasonable doubt is linked to the very low use of the regulation itself. So if the regulation itself is not so widespread as we thought at first, also the claim for verification of authenticity is low. Another reason could be linked to the situation in which doubts are connected to the translation, so to the multilingual form. Also, in this case, the regulation enshrines the possibility to ask for another translation, of course, in exceptional cases. In this, only when there are some problems with the translation of the multilingual form. So, for example, when you present certain documents, and on the document we don't have a legalization, and the doubt concerns the translation, so the attached the multilingual form, competent authorities can ask for a further translation when the present translation is not um, defined as correct. So also in this case, we could avoid referring to a process that maybe it's not that easier as translating again or revising again the translation. I tried to be quite brief, but maybe all my speech was not useful considering the numbers we have. So thank you for your attention. Thank you, Renzo. I don't know if we have any question. I would like then move on with the next speaker. But first, I would like to tell you that we have talked about problems of coordination among conventions. In this case, we have to tackle the complexity of a process of a tool. So maybe a question is, will this regulation really help us and help citizens and involve people? Maybe thanks to the outcomes of the DXB project, we will have some results. Let's now move on to the next speaker, who will talk about a national situation. So we will talk about a national case because Dominic Damian, I'm not able to spell the surname, sorry.
Of Law and Administration at the University of Gdansk, the School of Japanese Law and Okay, perfect. And Culture at the
Jagiellonian University.
In Krakow, the School of Chinese Law and Economy at the University of Warsaw. So you're going to speak in Japanese or Chinese?
English.
English, perfect. And now, right now,
Yes.
okay, now he is a PhD student at the Humanities and Social Sciences Doctoral School at the University of Gdansk. So now back in Europe.
Yes.
Perfect. And he's going to talk about transcription of foreign civil status records of children of same-sex parents under Polish law. Be precise, 12 minutes.
12 minutes? Impossible.
Do your best.
Hello, everyone. At the beginning, I must say that I'm very glad to be able to be here today live and speak on very serious matters. I'll try also not to speak too fast and do my best to fit in a given time. I would like to kindly thank to the organizers for preparing this final conference, as well as the audience for being here and listening. I think this kind of initiatives enable us to have an academic exchange, which I think is very important and needed. Today's speech was prepared based on the article that has been written together with Professor Małgorzata Balwicka-Szczyrba and Professor Anna Sylwestrzak from the University of Gdańsk. We decided to choose the topic that is very up to date and is socially relevant because year by year we can observe more and more issues that are concerning the topic that I'm going to present today. Before giving into the substantive of the presentation, I want to give you a general structure of my speech. So we'll start with the topic of the
Faster than this.
we'll start with the topic, aim of the research, the basic of the issue, discussion, and I will finish on the conclusions. So the topic on the speech focuses on the transcription of foreign civil status records of children of same-sex parents under the Polish law. And as I mentioned, it's more and more relevant and important in our legal system. And in the general perspective, the problem is about synchronizing the traditional family model represented in some legal systems, for example, Polish legal system, with more liberalized model of family relations that, for example, recognizes same-sex unions or same-sex marriages, depending on the country's regulation. And the process of transcription here is of fundamental importance because it's connected with identity of an individual, and it's inextricably connected with human rights. And we have here kind of a conflict that I will right now discuss. But from the other hand, it's also important to notice that implementing on or transporting some legal solutions that exist in other countries may disturb the stable system of family relations of a traditional family model, for example, represented in Poland. The aim of the research was dualistic. It was to analyze the issue of admissibility of the transcription on the topic discussed, which is a hard case that I'm going to talk a little bit lately, and to provide the solution proposal, both the legalata, so without changing the law, and the lega ferenda for our Polish legislator to implement the needed change in law. The basic of the issue, I think, of course, like civil status records have declaratory character. They only reflect, they do not create reality in a legal circulation, the new reality in the legal circulation. It's also important to say that they have a special evidentiary value, and this also includes foreign civil status records, and even if they are not transcribed to Polish civil status books. So the transcription basically is a transfer of the content of the foreign civil status record linguistically and formally to the Polish legal system. And it's based on the trust of findings of the foreign authority. And of course, the Polish head of civil status office have competences to check, to control the content of the foreign civil status document while doing a transposition. And there is a close catalog of grounds of a refusal of transcription. and it's really important. Also, the legal nature of transcription in Polish doctrine is described that it has a so-called reproductive character, which means that it's not about registration, but it's only about transposition into the official Polish language and form of registering. The essence of the problem is that, as I mentioned before, in Poland, the Polish citizen who has parents of same-sex parents can use either the transcribed civil status record, but here in many cases it's impossible, and I will talk about it, or he can use the foreign civil status record. So the question arises, why should the foreign civil status record be transcribed? Why do we need transcription into a Polish civil status record? And this comes with a lot of advantages. Exempli gratia, we can, for example, show about timing, because Polish heads of the registration office will not be uncertain of the Polish transcribed Polish civil document. But the problem is with foreign one, because the head officer will need to check a lot of different elements, which implies in timing. The decision will probably be taken much more later. It also, there is a need of sworn translation. However, it's good to mention that thanks to the regulation that was broadly analyzed during this conference, and also Vienna Convention, using multilingual standard forms and abridged civil status records helps and overcomes this sworn translation issue. But the core of the problem is that some regulations in Polish law stipulates that the transcription is obligatory, and this is the main issue, because the person, the child whose parents are same sex, they has a problem, because this child cannot have a passport, PESEL number, which is population number, very broadly used in Poland in many administrative procedures, Polish ID card, and even registration of other civil statuses. And also this implies many obstacles when it's necessary to prove the identity of the child. For example, enrolling a child in the current institutions like kindergarten, nursery, school, or even traveling within the Schengen area, because such a child cannot have an ID, because the head officer always will refuse the transcription. And this is a really serious issue. So moving on to the next part, we can clearly see the collision between child's interest in obtaining a Polish birth certificate in the cases that are the topic of my speech, and also from the other side, maintaining the homogeneity and coherence of a Polish registration system, which is also important and is very protected both by judicature and Polish legal doctrine. Many scholars criticize this solution, de lege lata, as a form of discrimination, because Poland is also obliged to ensure a certain standards for the child, and it may be seen as a very broad discrimination. In the light of current regulation, it's predominant in judicature and doctrine that refusal in such cases is the only right way in the light of current Polish legal norms. So there was a breakthrough in 2018 by Supreme Administrative Court of Poland. There were two very important rulings that overcame this dominant line. However, the next year in 2019, it came back again to this traditional refusal because of the Polish legal norms, and many scholars defended the integrity of Polish family law system. So we can clearly see there is the collision, and of course, like the ground of refusal was classically the clause of public order, which is presented in many legal systems. The conclusions, because it's important to see not only the legal system as it is right now, the regulation, but what can we do to change it. And it's important that we have to respect the welfare of the child as the leading principle, and this not only comes from international acts but also from Polish constitution and, for example, family and guardianship code. And it should be mentioned that we need to find a compromise solution. So the legalata, I mean, me and like my Polish research team, we have been thinking about possible ways of helping protecting the child in front of the regulation that is not yet changed. And we also came up with some conclusions for the legislator to change the law in next years, and hopefully it will also be the case. So the solutions, the legalata. So how can we protect the children when the transcription is being refused? So the first idea, I'll come up from the less integrating to the most far-reaching solutions. So the first one was to wait a second. This point. Yeah, sorry, I had to stop. So following the current line of ruling by administrative court, it may be stated that despite then inability to transcription of the birth certificate, it must be possible for Polish citizen to obtain ID cards or PESEL number. So even if the transcription cannot be done, it still should be possible as an exception for the child to get the necessary documents that are reflecting the basic human rights. And this would happen based on the foreign civil status record, and it's possible, but the Polish doctrine needs to also to accept this solution. But it's not solving the existing problem, because it's switching from the sphere of civil status registration to sphere of population registration, because the other officers will also need to, based on the foreign document, which in many cases is not translated, find out the way to issue the document without the transcription, which is also really crucial and hard to have. The second idea was to use so-called obscuring data. So the data inadmissible under the Polish law would be replaced with other data, and this is solution that is used in Poland for only for the father's data. So again, the problem is that the rubrics, the forms are not used to this kind of solution. So it also would be just a temporary way. The last two the last two more far-reaching solutions would be a partial transcription, but it's very hard due to the court rulings, and to leave some blank spaces, or even to allow the full transcription. And it's again the problem of the administrative form of making such a transcription, when in the Polish record there is literally a male and female spaces. We cannot just change the formula, because it wouldn't pass. So we can see that there are some solutions that can be implemented, but without further changes from the legislator side, without complex amendment, it's very hard to defend the basic rights of such a child in this kind of hard cases. And we came up with the idea, the legalata is the last one solution, the far-reaching when changing the law, but it's not so invasive, and it would be to put the unknown data in light of the Polish law in a special field on the formula, and it would be possible to refer to the foreign civil record status, but at the same time it wouldn't mean that we would implement new institution of same-sex parenthood to Polish system, but that we would only recognize and confirm that under a foreign civil status record, a child has the status of a child descendant from parents of the same sex. And I would like to thank you for your time. I must say it's sometimes quite hard to fit in time, but thank you for your attention.
Ho una domanda dal speaker.
Bisogna che me la traduci.
You should translate it.
Credo che si possono mettere i dati del padre, quindi ha detto che si possono mettere. Nell'esposizione ha indicato che
You said that you can omit the data of the father. It's one of the solutions. So that would mean if there were two mothers, one put aside means that the other one can be registered. But it could exclude any possibility by two men if we were talking about two men. We can do it with two men, but not with two mothers. That's what you're saying, basically.
Father, and what about when we have two mothers? Could we delete the data of one mother? So we have
no. What we meant with this the legalata solutions, what
Ti devo tradurre o c'è già il traduttore?
Okay, so what we meant with the legalata solutions was to find the way to protect the child under the current legal system, and each of the proposition was a different solution, but each of them had its disadvantages. For example, in this case, the problem is that in many legal systems we can have, for example, two mothers or two fathers, and the hypothesis of the norm that is the ground for this data cover. At the beginning, it wasn't adjusted, so it would be only a temporary solution that would at least give a basic protection to have issued the documents. But as we said, it's more likely to have the law changed. But if it's not changed, then at least we can propose this.
Does it happen in practice, the solution, or not?
Not yet.
Not yet.
Yeah. because the doctrine is all the time saying like there shouldn't be no transcription even partially.
Another question.
Since one Polish case is pending before the Court of Justice, the exact issue that is pending is that the birth certificate mentions two mothers. So there's no way that you can even retain one in Poland. That's the Polish-Irish. You're aware of it? Probably. So this is the reason why the case is before the Court of Justice, because Poland would say, I see two mothers. It doesn't matter who delivered the child. I can't recognize, I'm not trying to register this, because you don't have a partial transmission. You can't redact one part, remove one part, keep the other. That's the reason why the case is so difficult, right?
And it also depends on the exact like situation and what this child or his parents wants, right? But it's a very huge obstacle, and that's why it always gets really high. But right now the dominant, the only way is always denying, and we want to show that we want to criticize it and show that there are some possibilities even without changing the law and respecting our family system model.
So it brings me to the conclusion that it's a matter for the national legislators, of course, and this field show that policy considerations clash with fundamental rights and the respect of the best interests of the child. Few questions to thanks very much our prestigious speakers. I'm very pleased to have you here, and thank you, Alexander.
So, hello everyone. We will proceed now. We will proceed now with the closing session. Excuse me? Yes. So we will proceed now with the closing session on the future of public documents. Yeah, if we are ready. Okay, so we'll proceed now with the closing session on the future of public documents and their circulation in the EU, a dialogue among scholars, registrars, and lawyers. So our four distinguished speakers today, we'll invite them to speak for no more than 10 minutes, please. So we can then open up the floor to discussions. And we will start with Liliana Palmieri, Head of Demographic Services at the Comune di Treia, Italy. So after graduation, she practiced at a law firm for a short period. Since the 2nd of May 1996, she has been employed by the municipality of Treia at Macerata. Until the 31st of October 2014, she held the position of Head of Demographic Services with responsibility and coordination of the registry offices and toponymy, marital and electoral status, military service, statistics, and district electoral subcommittees. Since the 1st of November 2014, she has held the position of Deputy Secretary and Head of Sector 1, General and Institutional Affairs, Human Resources and Demographic Services. So a very useful perspective that she will bring to us, and I give the floor to you.
Thank you. Buonasera a tutti. Io mi sento di fare una prima riflessione, di ringraziare tutti coloro che in questi 2 giorni mi hanno preceduto.
In this 2-day talked before me, it was really a great experience to open the mind to other realities and to think about this topic with other people and to talk about this topic that it was really interesting. My analysis is going to be brief and it's going to include an analysis from the point of view of the civil institution. I want to highlight something. In Italy, people registration has 2 paths. The register that registers the population following the way it's distributed on the territory, and it's done with each individual and families, and then another official registers marriage, civil unions, death, and citizenship. These 2 people have one objective: to register people and to certify their status. These 2 officials had also another a change when Italy entered the European Union and the European market. With the regulation on the free movement, with the directive that we quoted ALAR, the 2004/38, that person had another competence, as to say, to verify the permits of people coming from the European Union that because of their job or because of study leave their country and they move to another country, a member state. And obviously this is perfect because this is a primary right and each person has this right. So this principle is fundamental. The principle that the European Union repeated a lot of times. That's why citizenship in the European Union is fundamental for the citizen. So everything seems okay. But on the operation level, it's important that citizens that move have a little obstacles to free movement. And one of the obstacles, the most important one, is the circulation of data and personal status. So during the years, the registrar started to get acquainted with these new practices that allow, beside the free movement of the citizens, also data and personal status. This happens because inside the European Union, we need to foster the free movement of the individual, but also the free movement of their families. If they cannot be with the individual, probably the individual is not going to move, and this is an obstacle and a great limitation. Being aware of this, these officials really know how to tackle these problems. From the 11th April of 2007, when the decree was implemented, the role that was of the police passed through these officials. And as the other official did before, the registry officers started to take care of the relationship between the spouses, descendants too, and these problems are really important for the communitary law. Obviously, the first instrument, the first tool that we know how to use is created by international conventions. The Vienna one, the number 16. This convention is really known by the registry officers and is really easy to apply and to implement. So these public officials are really used to visit the website of civil status to get to know better the topic. And they've been talking about it for a lot of years now. But let's talk about 2016, when the regulation was implemented, and the one we talked about during these days. How many people really know this regulation? How many registry officers know it? It is known, but it's less applied and implemented, contrary to the most famous one, conventions. Vienna, Munich, for example, and the others was the Strasbourg one. Why does this happen? Probably because it's more recent and because its application it's still critical. The speaker before me explained the difficulty. Caligione explained before me how verification in case of doubt is really complex. It can be done, but it needs more time. Obviously, each one of us wonders how is necessary to get closer to this instrument that is really interesting and important. I don't want um, to talk a lot, but I want to highlight this kind of analysis you're going to see. We have said a lot of things, and I want to create a summary with the point of view of the registry officers. What are the advantages of the regulation? For sure, this regulation doesn't need to be received because it's immediately implemented, and it doesn't need ratification. Some years ago, Romania, that entered the European Union in 2007, ratified Vienna Convention in 2013, and this was an advantage for Romanian people because it allowed them to demonstrate their spouse situation or parent situation or children situation when they needed to sign in the registry because they wanted to stay in a territory for more than 3 months. This is easier because in different parts of Italy, we have a lot of Romanian people, so it's easier. So the ratification of the Vienna was really an advantage. Obviously, this regulation is something more because it can be instanted, it can be used by every state member. So the advantage of the regulation is that it is an instrument for everyone. Another important, very important advantage is the abolition of apostille, which is a formality that normally it's used when a document is written in another state in which it should be used. It's a simplification because not always can be issued in less time. So the advantage is that it abolishes this formality for the documents that are subject to the analysis of the regulation. But let's talk about disadvantages. The form that is attached to the certification is long, really long. There are a lot of pages. It's less dynamic. Another problem is that contrary to the Vienna Convention and the Paris one, that is applicable for less countries, does not include it in the Vienna one. There are certifications that are issued with this convention can be done in few time because the format used for the certification allows the issuing of the form of Vienna with ABC, death, marriage, and so on. And this is really difficult. If we consider, for example, a citizen waiting is turn, it's better to wait less than more and to wait for the official to do everything, for the individual to do anything. And in this way, we can understand if in the future we can also optimize the issuing. Before we said that we are coming to a path in which all the acts are going to be digitalized in the future. We are getting closer to it. This means that probably, maybe, we're going to be able to implement in the future, in some years, the issuing of the documents with the new functionalities. The registry officers know the regulation, obviously, but the cases requested are not so much. The verification of this IMI system is difficult. A proposal that is really simple, we could think about eliminating from the document that is issued the multilingual glossary that could be downloaded by the authority that is going to examine the documents directly from the portal, the justice portal. So the 10 pages document becomes 4 pages. It could be a solution. Obviously, it's a solution that I consider practical. I want to thank you and thank you so much for listening.
For the very interesting presentation. We will now move on to the next speaker, and at the end we will have questions and answers from the audience. So our next speaker, I think I will give the floor to Steve Halen, President of the Flemish Association of Civil Services at Belgium. He is the head of the Service of Civil Status Office Leuven, the president of the Flemish Association of Registrars, and the president of the Management Committee of the Database of Civil Status Acts, and the vice president of the EVS, the European Association of Registrars. So over to you, Steve.
Hello, can you hear me?
Yes, we can hear you.
Okay, thank you. So I have some slides as well, and I actually prepared them for the former panel discussion about the regulation vis-a-vis other international instruments. But I will elaborate a little bit further on the future of the the regulation, because I believe this is at the core of this closing session, and this, of course, from a registrar's perspective. But first of all, Alexander and your team, on behalf of the EVS, the European Association of Registrars, and on behalf of our president, Mr. Simon Rijsdijk, who sends all his warmest regards, I have to thank you and congratulate you for this very, very interesting and excellent conference. Not only with the conference, but also with the work which was done in the project. And this project actually deals with our working field as registrars. It doesn't happen that much that science, academia is interested in our field of interest. And I do believe and I do think that the cooperation between academia and practice was very fruitful, and that it is shown in the deliverables of the project anyway. And that when I would wish something for the future, that we would certainly try to continue that. With the risk of repeating of things which were being said, I want to add 2 or 3 lines of thought. First of all, it was said yesterday already, I heard it today as well, the regulation is not well known and maybe not much loved, I would say. Why is that? The former speaker here in our session already talked about the paperwork of the multilingual standard forms. That is certainly an aspect which makes it difficult to love this regulation, because when you have to deliver a multilingual standard form, you deliver a small booklet of 15 or 20 or so pages. Of course, that's not the main issue, but it tells something, I think. Foremost, let us not be too severe. This regulation is still young. It only came into force in 2019. It's only 3 years ago. The world of registrars has a history for 200 years in most of our countries. And let's face it, it is a traditional world. And our colleagues, the registrars, they don't like filling out a multilingual standard form on a distant e-justice portal either. So that says something about the regulation as well. But there are means, there are possibilities to overcome this. Of course, for instance, when your multilingual standard form is added in your own national system, and you only have to push on a button of your laptop or computer. It is clear as well, and that was mentioned today by Marivo Travers, and there are exceptions too, but it is clear that generally speaking, the member states didn't do much in order to inform registrars, authorities, the practice, and citizens. It is like it is when you search for on government portals or on a municipality website. It will not be easy to find information about the regulation, about multilingual standard forms. When you try to do some searching, I think you will have to agree with me on that. It is my firm belief as well that registrars and also citizens lose track. We have national documents, often in different forms or different formats. We have, at least for civil status matters, we have the International Commission of the Civil Status Extracts. We have the multilingual standard forms combined with a national public document. Especially the ICCS extracts are still widely used and will be widely used because they have the advantage that they have legal validity, that They are accepted in third countries as well, all over the world sometimes. And that is certainly something we have to take in the back of our minds when we think about the future. It is this view of documents used not only in the Union, not only in member states, but all over the world, which is, I think, very, very appealing and very, very important, because we cannot limit ourselves to our part of the world alone. Another maybe disappointment for those who are familiar with the regulation is that we have this IMI or IMI system, which we can use, like Renzo explained, when we have reasonable doubt about authenticity, about the seal, about the signature. However, the IMI system is like a highway, and now I use the words of my esteemed colleague Rob van der Velde, who is with you over there. It is like a highway, but we actually drive on it with a little Fiat Panda. We could do much more. We could do much more. Much more traffic could be added. And I'm thinking, of course, and it is mentioned by several speakers, about the real electronic exchange of the public documents or the data it contains. And a problem there is that there are initiatives. We have the single digital gateway, which is coming, and the birth certificate, and also the to stay in the fields of the regulation. The attestation of residence are included there, and maybe we will come to in the future to an exchange there. But it will still be another instrument added to the already existing instruments, which doesn't make it easy for citizens and registrars to get the track of what they need and what needs to be presented in order to go cross border. I don't want to be too negative either. Only from the citizen's perspective, and that should be stressed all again and again, I think. Why do we work? Why are we in this world? Because we want to help the citizens, our citizens. Well, from the citizen's perspective, the regulation is already a success. It has abolished the apostille. It has abolished a lot of red tape, a lot of administrative harassment to get the apostille, a lot of costs for the citizens to get the apostille. And in many cases, the certified translations are not needed anymore as well, with all the burdens and not at least the costs which go with that. And of course, we can regret, and I do this as well, we can regret the shortcomings of the regulation. We can regret that nothing is in there and explicitly out of the scope of the regulation about the recognition of the legal effects of the documents which circulate around. But let us not forget that this regulation was and is a political compromise. It doesn't meet the expectations of the Green Book, but politics is not about the ideal, but is about the possible. And I firmly believe that if we all try to influence where we can those who are in charge, in the end, the legislator, on the national level and on the EU level, we can maybe in the future achieve improvements as well. It is for sure that due to the enormous mobility of our citizens, that the clock cannot be turned back, of course. Public documents will need to be carried cross-border, and the regulation is first an important step to facilitate in practice free movement as well. I would say let the regulation be like the cornerstone for just facilitating the documents to circulate. And let us try to elaborate on that. Let us try to add more fields in the future. Diplomas, professional qualifications, there are certainly things where we can think about. Let us add the provisions for electronic documents, which was a plea of Alexander. Let us perhaps create multilingual standard forms which are shorter and which have a legal value. I'm not against using the ICCS multilingual extracts by the EU, but let us not forget that there are also other fields in the regulation with multilingual standard forms, and that we also have to take care that we take them with us. And certainly, and that is my sincere wish, let us also push further for the electronic exchange of public documents or the data the public documents contain. Why not by expanding EMI or by using the ICCS platform which exists, or the SDG provisions. Whenever it works in practice, I'm there to support it. I would say, and that means in the end that we really have to try to come in a new era of international cooperation between different organizations, between member states, between states all over the world. Let us, like I said, let us not only look at the European perspective, but also think of it in a wider manner. And the HCCH is also present over there with you in Castel San Pietro. It is certainly something to think about.
Steve, we're running out of time, so if we could.
I will conclude. I just have
Thank
one
you.
more thing to say, and that is about the strategy, actually. I'm very much in favor of also working on circulating the civil status itself, and not only the public documents cross-border, but from a strategic thinking, I would say let us try to focus first on these electronic documents, on the electronic exchange, on the standard forms. Let us push that forward, because when we immediately make the connection with the recognition of the status, it is my fear that some member states will go on their back feet and say we will not accept to go further. That doesn't mean that we don't have to go further. I remember very well in the same room where you are sitting today, in 2017 at the EVS conference that year, Advocate General Paolo Mengozzi of Italy in the Court of Justice was there, and he said to us, we all should be registers of the Union. We all should be advocates of the Union from practice and academia. So let us stick together. Let the Court of Justice take up its role of motor as well, and let's work further on harmonization of applicable law, bill rules. Why not substantive rules as well? And I think a lot can be achieved if we work together, and that's my plea for today. And I give you back the floor. Thank you.
Thank you very much, Steve. And I will now give the floor over to Diana Padichova. She is a registrar of the municipality of Bratislava's district Devinska Nova Ves, representative of the Slovak Association of Registrars for the EVS, and graduate of the Faculty of Commerce of the University of Economics in Bratislava, with specialization in international relations, and diplomacy. And the floor is yours.
Thank you very much. Thank you very much for your invitation to this conference and an opportunity to being here with you. I would like to inform you about the application of the sorry of the regulation in Slovakia. It would be very briefly, and I would dedicate mainly to using of the multilingual standard forms, because in Slovakia, I can say that is quite widely spread, this issuance of these documents, of these standard forms, because it's the first multilingual extract we have since 2019. Before, we didn't have any opportunities to issue or to give our citizens any other extracts or public documents in other languages, only in Slovak or Czech, of course. We accept Czech language as the same as Slovak for acceptance of public documents. So this is the great advantage for Slovak registers. And but we have the big problem, which is mainly that our citizens who come from abroad, they don't know about the existence of these forms, because the registrars abroad in member states don't offer them that they will issue these forms for them to submit it in Slovakia. But the practice in Slovakia is that our registers offer our citizens these possibilities to submit it in abroad, mainly in languages German, of course, for submitting in Austria and Germany, but also Italian, French, Spanish, and Dutch, and English, of course. And I would like to say that our country is has just around 5 million of inhabitants, but every year the number of issued multilingual standard forms is increasing. In year 2019, it was around 6,200, and in the year 2021, it was over 7,000, and probably this year the number will be even higher. I work for a district of Bratislava, Devinska Nova Ves. It's a quite small district of the capital, and every year we issue around 100 of these forms to the public documents. So it's quite important for us. It's the only opportunity to simplify our citizens submitting the public documents abroad without it also saves their costs and also time. Maybe I would mention some problems we have. It's also the lack of knowledge of the registers abroad in the member states, that the possibility of the standard form there is. And as I said, it's almost very rarely that our people come, or also people from another member states country come to Slovakia with these standard multilingual standard forms. Mainly they come with certified translations. And maybe I would like to suggest that there's a little bit problem with the process of issuing these multilingual standard forms, because it has too many, as it was already said, too many pages, mainly the glossary, it's the other pages of the translations. So maybe in the future it would be necessary to think of if it's necessary to print them all. And as I think the future of the circulation of multi or the public documents in Europe or in the world is, of course, the digitalization and electronic forms, or also of these multilingual language forms, because it would be much easier, and we would also save paper and time and reduce the administrative burdens. So that's maybe very briefly our experiences with this regulation and the multilingual standard forms in Slovakia. Thank you.
Thank you very much to Diana for that fascinating view from the practice on the ground. I will now move to the last speaker, last but not least, because he's the heart and soul of this research project, and he barely needs an introduction, but I'll introduce him anyway. This is Alexander Schuster. He holds a dual doctorate from Trento and from Strasbourg University with a thesis on gender-neutral family institutions, with mention très bien avec félicitations, and a diploma from the European Public Law Organization. He's currently a researcher at the University of Graz, Austria, from where he coordinates the EU co-funded project Identities on the Move, Documents Cross Borders. So the project that has created the final conference at which we are now participating. And previously was lead researcher of the Rights on the Move, Rainbow Families in Europe, and of the project Equal Jazz. He acts as a board member for the Center for Gender Studies at the University of Trento and of the Euro Regional Association for Comparative Public Law and European Union Law. Alexander coordinated major interdisciplinary research, notably one for the Italian government on LGBT and T discrimination in the south of Italy. He is an Italian attorney with pioneering work in the field of family law and assisted reproduction techniques. He acted as an independent legal expert to the European Commission, DG Justice, and the Council of Europe. He has taught and researched at universities and scientific institutions in Heidelberg, Innsbruck, Trento, Lund, Montreal, Toronto, Washington, D.C., Pristina, Athens, Strasbourg, and Udine. And his academic interests include fundamental rights, European Union law, non-discrimination law, and the new legal challenges posed by bioethical and technological research. And he has published in various legal fields ranging from American law to European Union and comparative law. And I'll yield the floor to Alexander for his remarks.
Ich werde jetzt kurz auf Deutsch reden. Ja, es ist jetzt bereits 5 Uhr und wir haben jetzt noch eine Viertelstunde und ich glaube, wir waren diesen 2 Tagen ziemlich fleißig, haben wirklich viel darüber überlegt, wie diese Verordnung angewandt werden sollte und was noch zu machen wäre. Ich bin neben Akademiker ab und zu mal auch Rechtsanwalt und eigentlich wollte ich hier am Rundtisch als Rechtsanwalt reden, denn mein Interesse an den Personenstand stammt eigentlich nicht aus meiner akademischen, sagen wir mal, Laufbahn, aber eher aus meiner beruflichen Erfahrung. Denn wie man sieht, man spricht sehr viel über Familienrecht.
So as we can see, we speak a lot about recognition, family status, but often the civil status in the member states
die ja normalerweise
between rules we have a form, a questionnaire, and a child, so that you really understand how many fields are involved. For example, in Poland, either everything or nothing.
Now, in regard to the notaries in Austria, and I think yesterday it has been mentioned already, we organized a seminar for the notaries, which was really successful in Italy. I think it was in April. Giacomo is not here anymore, but we also organized a seminar for the lawyers in April. And there were a lot of lawyers who showed interest in the regulation. And now we are going to do more on the website of the project. There are a lot of tutorials that are offered, and you can also find further resources that are not only targeted to notaries, but also to lawyers and registrars. We were not able to cover all target groups. Something that we have forgotten about are the judges. We don't know if the judges know about this. Usually we think about the registrars in Germany or in Italy, for example. This was our main target group, but judges should also understand this regulation, understand how it works and what it means for official documents. So if we, for example, have a look at the framework and application on divorces, does a marriage certificate have to be recognized in a civil status and registered there, and then only you can go in front of court to apply for divorce? Or can you directly apply for a divorce without the marriage certificate being registered previously in the civil status? Judges, but also notaries and lawyers have to deal with these things, and we've stressed this. The regulation is not very well known and is not really in use, but I think lawyers and notaries should show a higher interest in the regulation. And by the way, there are many opportunities to make use of resources in regard to this regulation. Let's think about all the translations that usually have to be done for all documents. So if we think about rainbow families, they adopt in France or in Germany itself, where a double motherhood was not possible at the beginning. And then the clients ask, which certificates do you need in your member states for it to be recognized? And usually they send a list with all the official documents that are necessary without apostille already for some time. I'm working in Italy now, and there are a lot of agreements with other EU member states in the framework of the International Commission to make sure that civil status matters are dealt with in a unified way. So apostilles and legislation is not required anymore, is not a problem anymore, and therefore is not a bureaucratic hurdle. But a translation is necessary, and in some countries there still needs to be a apostille or legalization. So as I've said, we should introduce the regulation among lawyers and notaries and offer the necessary information to them so that in their daily work lives they use the regulation more. I don't know how it's in Slovakia, because probably there it's used more often, because if there are no other opportunities to use, if you need a multilingual form, probably it's more in use as compared to in other countries. So we have more focused on registrars, but next time maybe we should focus on lawyers and notaries.
Thank you very much to Alexander. And now I open the floor to questions from the audience. I might then exercise my privilege as the chair. Oh, you have a question? Oh, no, go ahead. Thank you.
Thanks a lot. Just not questions, but some comments, especially about the first speaker, Mrs. Palmieri, but I think she's left. I was just wondering if the absence of ratification of the regulation has been presented like an advantage. I'm not sure that it's really true, because we have seen it, we have experienced it in the frame of the ICCS. Ratification, of course, might be a complicated process, but it also means that a state needs to be prepared. And I have sometimes the feeling that the regulation has just he's just coming from nowhere for some member states. Marie Vautravers has not mentioned some states which are still not really ready. There are no informations for the staff concerned. I know very well the country concerned, and really I think that if ratification might be sometimes difficult, of course, it's a political process. It also helps a lot to prepare. It means that we already know that, for example, our convention ICCS number 34 will be applied in the different member states. So I think that it's difficult to consider that it's really an advantage. And second point, very quickly, our website has been mentioned. Just to tell you that in a few days we will have a brand new one, so you will have much more informations about the conventions, but generally speaking about civil statutes. Thanks a lot.
Thank you. I don't know if any of the speakers would like to comment on this.
I'd just like to underline the importance of the ICCS. Even when we carried out our comparative survey, we tried to collect as much information as we could from the member states. For instance, we had no idea what was going on in Malta and Luxembourg because we couldn't find an expert. But then, just to underline the website, and I look very, very much forward to the new website, because you can't link except to the homepage of the website, which is not even CIEC, but you have to be ciec1.org, but you find it clearly. And there's a wealth of information on how civil status works in the member states. Maybe it's not very much up to date, but still, some reports are 3 years ago, 4 years ago, some are a little older, but you can find information on the structures, the main structures in many countries. So there are proceedings of all the wonderful conferences. So there's a lot of material that for us was very, very useful. So it's worth for anyone working with this area, but as we said, with the details of civil status, not with the great, issues of marriage and also that. We also find this because when the specific feature of the International Commission, that is far beyond the reach of the regulation. So you really know to compare issues of order public, of public policy. So there's a wealth of information on both sides. How family law and civil status works in the member states, and also a lot of information on how the formal aspects of civil status, and also the Hague conference had a lot of materials, the questionnaire around the apostille convention. So we looked into that website, and we really thank the Hague conference for providing us with documents, materials, guidance when we had discussions over the implementation period of our project, and also some other publications clearly in academia. And the British Institute carried out a very important comparative survey now 12 years ago in view of the regulation that will have to come. So yeah, there is materials a bit around the internet that was very, very useful to us. So, but as I said, thank you for providing over so many decades so much information on civil status and doing that still today. So thank you also for what you will do in the future.
Any other questions? I might exploit my position as a chair then and ask a question to Diana, sort of echoing what Alexander hinted at, because it seems very interesting that a small country seems to be implementing the multilingual standard forms quite more than other countries. So do you have any idea why this is happening, or do you have any best practices that you use to raise awareness with citizens to use the multilingual standard forms?
Okay, thank you. As I mentioned, it's probably because we didn't sign the Vienna Convention in 1976, so we didn't use in Slovakia the CIEC extracts. Slovak language is not also in these extracts of ICCS, so we cannot accept them in Slovakia, and therefore we asked our people. We asked our people to ask them, require them abroad, and inform them about the possibility that they don't have to translate the document, public documents. They need to submit abroad. So we offer them this possibility because it's advantages also for us and mainly for the people. As I've already mentioned, the only one of the disadvantages is that it's a little bit time. It takes quite a long time to produce it, to issue it, because it has several pages. Quite many pages, and so we need to put all the data to the form. It's not automatically electronically put to the form, but we've got to write it down there or fill it in. That's it. Okay, thank you.
Just wanted to add one aspect that it's within the regulation. It's very quick. It's that the regulation allows member states to incorporate, actually even encourages to incorporate member states, encourages member states to incorporate the multilingual standards forms within their systems, their databases. And by doing so, they don't necessarily mean that you really need to stick to the layout of the annexes, because you can, as long as you provide information of the multilingual standard forms. So it is true, and it's been raised many issues, and Rob always allows, how many pages do we have to print out every time we issue multilingual standard forms? What about, also environmental friendly approach to the matter, etc. Those states that have already incorporated multilingual standard forms within their databases, actually haven't seen the outputs, but it's not necessarily bound to really the layout of the annexes, because I think the annexes are really conceived for those that see the world either on paper or as digital PDFs. But an electronic document, as we have underlined, it's not just a PDF. It's not just a digital image. It's much more. It's a flowing text. So there are so many options there that could be explored somehow to reduce the waste of paper, or just to really select information that's needed and strictly linked to the regulation. But we'll see. Maybe next time we meet in Castel San Pietro, we can further develop the electronic dimension of the regulation again.
I think if there are no further questions, yeah, I see one question online, so that's the last question we'll take, and then we will conclude. Thank you.
Many thanks. I will be extremely short. It's not a question. I just wanted to highlight the fact that indeed 10 member states have integrated the multilingual standard forms in their IT system, which makes it much easier for registrars to issue those MSF. Plus, I wanted to highlight the fact that the EU is actually providing fundings for this. So it's at the end, it's free for member states to integrate the forms in their IT system. They just have to do the IT work, but the fundings cover everything. That's it from my side. And thanks a lot for the very interesting afternoon.
Thank you very much for that last comment. And if there are no further questions, I think we shall conclude and invite Gregor, I think, for... And Rob?
Rob, you can represent EVS with two... No. Okay.
So for some final remarks. Thank you.
It's just a closing. You know, Steve Hyland is online? No?
So it's giving the task to make a conclusive statement at this conference, which has been extremely interesting, extremely stimulating. It has been fascinating, not only because of the place where we are, but mainly because of the contents, the ideas that inspire us for the time that comes and for the developments that this regulation will see in the future. I will be very brief here because I know we are all tired and this is the end of the conference. We've heard from the European Commission that the regulation works very well. In the beginning, we said, well, there was scarce application, that's the hypothesis, and this was repeated, and I think all at least most of the reports from the single countries, from member states, show that the application of this regulation is still scarce, and this mainly, I think, has to do, at least we've seen it with Slovakia, that those member states who signed the CIAC conventions, the ICCS conventions, they still continue to use these extracts, these multilingual extracts, while the other member states who have not signed these conventions really use the regulation a lot. So there is a big difference between member states depending on whether they signed or did not sign these conventions. We've taken a very deep look into the regulation. We've seen a lot of gray areas, and I would like to mention especially e-documents. We've talked a lot about digitalization, and this is also the future of this area. I think the future should be that public authorities exchange public documents directly without the citizen being in the middle. This will be the way in which many problems that now are solved by way of trying to reduce formalities, adding multilingual standard forms, and so on. All this will be the past as soon as public authorities communicate directly on the basis of a system that might be this single digital gateway or any other system, for example, the IMI, which is said to be able to develop also into this direction. What we've seen also is that this regulation takes us far beyond its scope of application. At least there is a desire to take it far beyond its scope of application. We know that it does not imply the recognition of the effects of these public documents. And still, we've had a lot of speakers who talked about what it means to recognize the instrumentum for recognition also of the negotium. And we've seen that the European Court of Justice pushes into this direction. And this might be also part of our future, that we see the European Court of Justice going further, even though not imposing on the member states to harmonize family law and status law issues, but still giving the whole theme a framework that will allow or will make it very difficult for member states not to react to this. And we've seen that in Bulgaria, the reaction of the court, which said, well, you have to accept this birth certificate. And we'll see that in many other cases in the future. So for the time being, it's just the instrumentum, but for the future, it may be much more. So that leaves us a lot of space for developing, for discussing in the future. And this is what makes this topic so interesting and exciting. And that I hope you will continue with the work on this. I also conclude in a sense that I would like, in the name of everybody, thank you, especially our host, Anuska, for this wonderful organization of this event. We are so thankful for having been able to do this. Of course, to Alexander Schuster for his invaluable work that he has done for this project. I don't know, maybe it's not my task to say it, but I say it because I'm at the end of this conference. So thank you, everybody, for being here and for having participated in this conference. You have made it a great event.